May please, your lordship. Lordship, with regard to item number 41, against his judgment of slurred and single judge, an appeal has been filed, your lordship, which has been stayed. The order has been stayed, your lordship.
The matter can be adjourned for 4 weeks.
Right. You are appearing for the other side.
On the respondent, full respondent.
Then we'll adjourn it for 8 weeks.
Yes, sir. Thank you, Lord.
Mr. S. Gautam, learned counsel for the petition, item 41. Submits that an appeal has been preferred against the judgment and order of the learned single judge, whereby the division bench has stayed the operation of the order. As such, this contempt case be adjourned for 8 weeks, awaiting the outcome of the writ appeal. Mr. A. Das, learned counsel for the respondent, is present and does not have any objection if the prayer is allowed. In view of the above, this matter be listed again after 8 weeks for necessary orders.
Please, your lordship. Lordship, with the consent of the opposite side, beg to mention item number 2. The matter may be adjourned for a day. The conducting counsel, Mr. Firoz Khan, is not available today.
So on the prayer of learned counsel for the petitioner, this matter stands passed over for the day.
May I please, your lordship? Lordship, with the consent of the other side, I beg to mention item number 16, my lord. We need 2 weeks time, further weeks time, my lord.
Mr. S. Dr. Learned Standing Counsel, PNRD Department, Assam 6, 2 weeks further time in this case to obtain instruction and file affidavit.
Right.
Since the prayer is made with the consent of the opposite party, the same stands allowed. Let this matter be listed again for admission after the ensuing puja vacation.
My lord, I'll leverage that.
I'm for the other side.
I beg to mention item
You're for the
32
other
minutes.
side.
Yes. Item number 32 minutes.
I'm there.
32, 32 minutes.
Yes. What
There's a
what-
fixed item minutes. I'll pray for some time today minutes. Some instructions will come.
Mr. D. Gogoi, Learned Standing Counsel, Forest Department, Assam, prays for 3 weeks time to obtain instruction and file affidavit in this case. Since the prayer is not opposed by Mr. S. Banik, Learned Counsel for the petitioner, same stands allowed. Let the matter be listed accordingly.
Interim order.
Interim order passed earlier to continue until further orders.
May I please?
I beg to mention item number 34, my lord. That has become infrastructure, my lord.
34 has become infrastructure.
Mine.
Why?
And it's a transfer order, 2017 transfer order, my lord. More than 6 years. There is no
Mr.
interim order.
Other Learned Counsel for the petitioner submits that in this writ petition, a transfer order issued way back in the year 2017 had been assailed. Full stop. There is no stay order,
No, my lord.
but no stay order is operating in this writ petition. Therefore, full stop. Therefore, the matter has become infractious. Who's for the health?
Okay.
Standing Counsel Health.
Legal counsel.
Anybody there?
D. Gora.
Ms. D. Bora, Learned Standing Counsel Health Department is present and supports the safe care. In view of the above, this writ petition stands disposed of as infraction.
Already.
May I please, Lordship? Lordship, I beg to mention for listing one writ petition, Lordship. It was supposed to be listed the first week of September, Lordship. They're not yet listed, Lordship. Next Monday, Lordship. Well, much obliged, Lordship.
May I please, your lordship, I beg to mention item number 9. The matter may be listed after 1 week, madam.
You are for the petitioner.
Yes, madam.
On the prayer of Learned Counsel for the petitioner, Miss, your name please?
K. Burman.
K. Burman. This matter stands passed over for a week. List accordingly.
Obliged.
May it please, my lords, I beg to mention item number 44, my lords, with the consent of the other side, my lords. I'm praying that the matter be taken up on 20th, my lords, with a connected matter, which is already fixed on 20th.
Item number 44.
44, my lords.
Mr. B. Chaudhary, Learned Counsel for the respondent, submits that similar matters are fixed before this court on
On 20th, my lord,
20th of
September, my lords.
September 2024. Therefore, this case be also posted along with WPC number, along with
Contempt case number 201 of 2024.
201 of 2024. Since the prayer is not opposed, same stands allowed. Register to list the case accordingly.
I'm deeply aware.
May I please, Lordship? I beg to mention for listing one admission matter, matter relating to compulsory retirement matter. On a single incident, without considering the entire career, and the after inquiry, the matter placed
Listing for what?
admission.
Next week.
Congress.
Lordship, I beg to listing for withdrawal, Lordship, on tomorrow, Lordship.
Your Lordship, I beg to mention for a listing of an missed case along with 3IA on Friday, Your Lordship.
May I please, Your Lordship? Lordship, I beg to mention for a listing of WBC matter. It's a service matter, Your Lordship. Can it be fixed on
The service matter, this bench is for service matter only.
local bodies, Lordship?
You can't have a land matter listed here. Why you want it to be listed?
It's a removal from service of the local bodies.
We'll have it after vacation.
Lordship, there is another matter. It's a
Mentioning is permitted only in case of urgent orders. Otherwise, no.
Lordship, can it be fixed on 24th, Lordship? A date may be fixed, Lordship.
After vacation. Put a date after.
Okay, Your Lordship. Lordship, I bring for a listing of a WBC matter related to promotion.
What is the urgency?
My lord, at any time the departmental proceeding may sit for a promotion and
It's a
by,
pending matter.
no, my lord.
First listing. First listing.
Yes, ma'am.
Day after tomorrow.
God bless, ma'am.
Daily list for withdrawal item 1.
Mr. BK does not counsel for the writ petitioner submits that he has instructions from his clients to
Withdrawal with liberty.
withdraw this writ petition. Why you want to withdraw?
My lord, we are receiving some documents, and my lord, we are going to annex it, and my lord, some in the pleadings also some amendment is required to be.
Mr. BK does not counsel for the writ petitioner submits that there are some defects in constitution of the writ petition. And certain additional facts are also required to be brought on record. As such, he has instructions from his clients to withdraw this writ petition with liberty to file a fresh. The prayer is not opposed by Mr. N. Upadhyay and is standing counsel for the Irrigation Department. In view of the above, this writ petition stands disposed of on withdrawal with liberty.
For motion item 3.
May I please, Your Lordship? Matter is regarding non-payment of provisional pension, Lordship. On 28/2/2024, instruction to shortfall. The persons superannuated on 28/2/2022. Right.
Lordship, we have received one instruction from the office of the SP, Lordship. The pension proposal was submitted to the senior accounts officer, office of the principal accountant general Assam, right, so and so. It is and it is a fact that Lordship petitioner has received subsistence allowance of 50% per month of with effect from 31/5/2021 to 38/2021 and
What
70.
does subsistence allowance got to do with pension?
Otherwise, Lordship, we have sent up pension papers to the AC, Lordship.
Sent when?
Lordship, 12/3/2024.
Who has given you this instruction?
From the office of SP Dhubri, Lordship.
What happened? Huh? All right. Take down. Heard Mr. D. Chaudhary, learned counsel for the petitioner, who submits that despite having retired from service on attaining the age of superannuation with effect from 28/2022, even the provisional pension has not been paid to his client till today. In terms of the earlier order passed by this court, Mr. C.K.S. Borwa, learned government advocate Assam, has obtained instruction from the superintendent of police Dhubri and submits that pension papers of the petitioner was forwarded to the office of the accountant general bracket A&E bracket close Assam on 12/3/2024. Mr. D. Bhattacharya, learned standing counsel, appearing for the office of accountant general 6 time till 23rd of September to obtain specific instruction with regard to the above submission of the learned government company. One extra copy of the writ petition be furnished to Mr. Bhattacharya during the course of the day. Register to list this case again on 23/9/2023 as a fixed item for more. But if it is found to be incorrect, then there will be serious trouble.
Then SP will answer.
You better tell him that.
I'll file out the affidavit.
Item 4.
May I please, your lordship. Lordship, this is the second round of litigation, lordship. Earlier, the petitioner along with two others preferred writ petition before this honorable court. That order is at page number 135, lordship. The 11th portion is at page 139. Last paragraph, lordship. In the light of judgment passed in Gaurav Pradhan, lordship, the respondent authorities were directed to consider the case of the petition, lordship.
What is
They have-
happening? Where is the earlier order? Which page?
Yes, page 139.
1.
Lordship. Earlier writ petition orders. Relevant paragraph is at page 139. Last paragraph, lordship.
Yes, so what has happened after this order?
Thereafter, the respondent authorities rejected the claim of the petitioner, lordship, which is at page 140, lordship. This is a type copy, lordship. And page 140, last line. It starts from last line. Since you secured less marks and did not find a place in merit and declared non-qualified, lordship. But I applied for under the OBC category, lordship. The lowest marks which was considered, that was under general category, which is at page, lordship, 105, lordship.
No, we have to issue notices.
Lordship. Lordship, in the interim, at least one post may be kept vacant. Lordship.
Vacancy not available, lordship.
Lordship, out of 10,665, 10,228.
No, in fact, we record it. It is only because of the learned CGCs who are not opposing. We are passing these orders. Because nobody is opposed. The department cannot take this plea that there is delay. They will have to take either action against their officials or they will have to action. Nobody is raising this plea that these petitions are delayed. Otherwise, you don't get any relief in these cases. No order. They are inviting these orders. You
Similar,
are inviting
yes,
these
lordship.
orders. Yes.
Similar
You
matter,
cannot deny relief to anyone on the ground of delay.
yes.
You do
Similar
it-
matter is already, a similar matter
Hmm.
has already dismissed by this court on 28/6/24 on delay and laches.
On what ground?
Delay and laches.
Delay you cannot.
No.
Have you raised this plea here?
Yes, lordship.
Where is
No.
it? Show me.
No, no.
No,
On the
no.
order.
No. In that order, it was
That
not
order
raised.
not met.
Then you can delay.
That
will
is
not
of
be-
2024,
If
lordship.
it succeeds, then you have to create a superannuation post.
That order is of
You
5.
have not raised the plea of delay. Then delay you cannot raise now. Last week also there were 2-3 matters, nobody even appeared. The court wanted to dismiss it, nobody appeared. So those cases you will have to grant relief. You figure it out with your departmental people and your office. But if you don't appear, court will pass orders. Anyway, heard Mr.
Majumdar, lordship.
So and counsel for the petitioner, there is the amendments made in the petition being agreed by the order dated 25/2024, rejecting the prayer of the petitioner for appointment in the post of constable judicial. The petitioner has approved the report for the second time by filing the instant writ petition, inter alia containing that the case of the petitioner has not been considered properly in terms of the earlier order of this court. Mr. Mrs. Burwell and its secretary appearing for the respondent's place for some time to seek instruction. If you notice returnable in 8 weeks. The respondents are already represented by the learned CGC. No formal notice is required to be signed in this case. Extra copies of the requisition become a requisite in number. Be furnished to the learned department council so as to enable the instruction. They have this rejected your claim on merit.
No, lordship. I applied under OBC category. I secured 44.69 marks, and the lowest marks considered, that is of unreserved category, lordship. That was 44.84. So I may be considered, lordship, because of OBC category,
Next
lordship.
matter, please.
Oblige, lordship.
Item 5.
Pleasure, Lordship. Lordship, pair part of the petition is not complete, so I file IA, Lordship. The IA has not been taken with record, Lordship. So kindly call the IA, Lordship.
Your name, please?
Yan Borua, Lordship.
Mr. N. Guru, I shall submit an interlocutory application arising out of this petition, which was filed on,
File on, Lordship, last Friday, Lordship.
was filed on 13/9/2024, is not tagged with the record of this case. Therefore, on the request of Mr. Borua, registry is directed to take the IA and list this matter as on Friday date for motion.
Most of
Item 6.
On last occasion, Lordship asked me to obtain some instruction, Lordship. I have instruction. Lordship, para 2 specifically.
So now the chairman is not drawing any pension.
Lordship, this is governed by this new rule, Lordship. I have given the flag mark, the rule even also, Lordship. Yes, new rule, where all these are governed by 3(3) of the ERC rule 2017.
What is the
Lordship.
instruction is not, I have not understood. What does it
I'm
mean?
appealing for the regulatory commission for as per the number 6, 7, 8, my lord.
Ah,
I'm not received a copy of the petition,
No, notice issue, not yet issue, notice.
my lord.
Ms. Bhattacharya, what does this
Lordship,
instruction mean?
As per rule
Just a
3,
minute.
Lordship.
The chairman was a former bureaucrat.
Yes,
Who is
Chief
the
Secretary of
Chairman,
Assam.
yes, Lordship.
Chief Secretary of Assam.
So he is a former government servant.
Lordship.
He is getting
Minus,
pay minus.
Minus.
without minus, yes, not.
Without deduction of pension, he is getting the full pay. What about the petitioner? Petitioner is a former government.
No, he's a PSU, my lord, state PSU.
State PSU. So why is this
Lordship,
distinction?
Rule 3(3), Lordship.
3(3).
Yes, Lordship. I have flag marked this, Lordship. Of the notification of 11 January 2018, Lordship. Rule 3(3), if a retired High Court judge or a retired official from the state or central public sector undertaking or autonomous body is appointed as chairperson, member, as the case may be, he will be entitled to avail the benefit of apex scale fixed by Government of India as above, minus pension notionally arrived at 50% of his last pay drawn. And if no pension is drawn by the retired High Court judge or the official, then he will avail the full benefit of apex scale as fixed by Government of India and or revised from time to time.
All right. So the chairman who was a former chief secretary,
Lordship.
he is covered by 3(3).
Regarding
He is also a retired official from the state or central public.
Yes, he's covered, my lord. Actually, he's covered. But his case,
Chairman.
by lord, page 33, your lordship kindly see. I have annexed that rule.
Huh?
I have annexed that rule and
So High Court judge and officials of state or central public sector or autonomous body
they will not get.
they will not get and others will get.
Lordship,
We'll quash
this is a
You
minus
decide the
50%.
date, we'll quash it. We'll quash this rule.
Lordship.
What is happening in this state? There is a limit to extending favors. Challenge this, quash this rule.
No, actually, the rule is very clear. They have misinterpreted it, my lord. Your lordship kindly see.
Yes.
May I read it, my lord? Page 33. Page 33, my lord.
Page 33 of the petition, my lord.
Yes.
I have annexed, my lord. By amending, my lord, they were granted, my lord. Your lordship kindly see. Page 33, my lord.
Yes.
Clause 3(3).
Yes.
If a retired High Court judge or retired official from state, your lordship kindly stop there, or central government public sector undertaking. Your lordship kindly see now where does now two person, my lord, working there. Chairman is the, my lord, retired chief secretary, and my lord, the other one is, my lord, retired district judge, is a member law, and I am a retired public sector of Assam, state of Assam, and I am technical, my lord. And now other two, they are getting salary full, but I am getting salary minus, my lord, pension. Your lordship kindly see, in that way, my lord, they are also not entitled, my lord, but for them, my lord, there is special, my lord, there your lordship kindly see, page 43, my lord. Page 43, your lordship kindly see. Earlier also, they have not getting, my lord, but they are especially by after this order dated, my lord, annexure 10, page 43, my lord. Order dated 6/10/23, may I read it, my lord? With reference to the above, I am directed to convey the approval of the government in the power and electricity department toward the allowance of apex scale of Indian administrative service in respect of the present chairman and the member law AERC without deducting their pension from the salary. Further, it has been decided to propose before the Honorable Cabinet for approval for the amendment of the rules regarding pay and other terms and re-employment chairperson and members law AERC in principle of last paid minus pension as adopted in APSC. Hence, you are requested to prepare the draft cabinet memorandum for the purpose of furnishing the same into the department for onward submission of the Honorable Cabinet. So that was, my lord, specially they were granted. And immediately, my lord, came to know I filed a representation. My representation is pending for last 1 year about. No decision has been taken, my lord.
No, better. Whatever.
So, Ms. Varjaji, what is
Lordship.
why this distinction?
Lordship, that's what lordship kindly fix it tomorrow, lordship. On that particular point, I will obtain this. Whatever on this October 23, this notification, lordship. Or lordship may issue a short notice, lordship.
Is the accountant general a party here?
No.
You are appearing for whom?
I'm appealing for the commission, madam.
Huh?
For the commission, for 5, 6, and 7, madam. 6, 7, and 8, madam.
And lordship.
Lordship may issue
is
notice,
there.
madam. Will file affidavit, madam.
My lord.
Short notice, madam.
Finance department is also, that means their response is also required, lordship.
So why you have not made them parties?
The finance
Finance is party,
finance
lordship.
party, my lord,
No,
this is
Response number
AG, you have
AG, my lord, this is not salary, this is not pension, this is salary only. That's why I'm not made permanent. Finance is, my lord, main, my lord, authorities for finance, my lord.
Mr. T.J. Mohanty, senior assistant by Sharma, I counsel hearing for the commissioner. Peruse the written instruction obtained by Ms. M. Leonard, additional senior government advocate. Full appeal for the state. Numbers. That is respond numbers. Your first.
I'm for lordship, 1 to 4, lordship.
Respond number 1 to 4. A perusal of the instruction goes to show that by relying upon the provision of rule 3, bracket 3 of the Assam Electricity Regulatory Commission, bracket salaries, allowances and conditions of services of chairpersons and other members and subscribing to oath of office and secrecy by chairperson and other members, bracket close, rules 2017. A different criteria for payment of salary to the former IAS officers and the other category of personnel engaged as chairman stroke members of the commission have been adopted. Full stop. According to the lead petitioner, such an approach is discriminatory and therefore deserves to be struck down from this court. Full stop. This issue would, the issue raised in the lead petition cannot be decided without the affidavits being brought on record by the respondents. As such, issue notice of motion returnable on 1st October 2024.
First October.
Since Ms. M. Bhattacharjee, learned additional senior government advocate Assam has accepted notice for respond numbers 1 to 4. Mr. S. P. Das for
6, 7, and 8, madam.
H. Olia, learned standing council finance for respond number 5, and Mr. S. P. Das, learned standing council AERC for respond number 6, 7, and
7 and 8, madam.
6, 7, and 8. Service of notice is deemed to be complete in this case. Extra copies of the lead petition are requisite in numbers will furnish to the learned departmental council so as to enable them to obtain instruction and file affidavit on or before the returnable date. Deputy.
Oblige, your lordship.
Item 7.
May I please? Lordship, matter relates to my lord for retention of my lord, the government accommodation, my lord, water matter at the last place of posting, my lord. My lord, petitioner, my lord, posted here, my lord, Northeastern State, my lord, at Itanagar, my lord, by transfer order dated, my lord, 14/12/2023, my lord.
There are similar orders.
Yes, lordship, lordship, even lordship passed, my lord, the, I have annexed, my lord, one similar order, my lord, page, my lord,
Page.
page 107, my lord. Not to take any courtship action, my lord. And my lord, page 96 also, my lord.
Heard Mr. Ellen Denivia, learned counsel for the petitioner. The lead petitioner hearing is serving as commandant, bracket TELE, bracket close, Indo-Tibetan Border Police, ITBP, and posted in the posted at Itanagar, Arunachal Pradesh, which is considered to be a non-family station. The case of the petitioner is that, as per the existing norms, the officials who were earlier posted in New Delhi
Lordship,
and were transferred to non-family station were entitled to retain their residential accommodation for the family members. However, after the OM dated, which is the date of the OM?
OMC 6/10/2023, my lord, that is Annexer 8, my lord, page 86.
After the OM dated 6/10/2022, the said position has altered and the officers are now compelled to vacate such residential accommodations. Contending that similar petitions wherein the same issue is involved is pending, are pending before this High Court, wherein interim orders are authoritative. By referring to the interim order dated 3/4/2024, passed by the Learned Civil Judge, WPC number 1829/2024, the petitioner's counsel has paid for interim relief. Ms. A. Gayan, Learned CGC, appearing for the respondents, has admitted that similar petitions are pending before this court, wherein interim orders are operating. In view of the above, for the sake of uniformity in judicial orders and so as not to cause any prejudice to the petitioner, this matter, in the opinion, of this court also deserve similar treatment. So, as such, special notice returned in 4 weeks. Since Ms. Diane has accepted notice for all the respondents, no formal notice is required concerning this case. Extra copies of the petition will be furnished to the learning CGC so as to enable her to obtain instruction heard on the prayer of interim relief. Having regard to the facts and circumstances of the case, it is hereby provided that till the returnable date, no coercive action shall be initiated against the petitioner in terms of the office manual dated 6/10/2022. Will this petition be listed along with so and so?
Item 8.
Petitioner before Lordship because that ROP 2017 has not been implemented by the board. It has come into effect from 1/4/2016. Madam. There are large numbers of cases have been pending, madam. At this time, I am only paying for notice, madam. Similar case.
The read petitioner herein is agreed due to the fact that he has not been extended the benefit of revised pay scale under the Assam Service bracket ROP bracket code rules 2017. For a period of about 28 months, coinciding with the date of his superannuation. Miss
I'm N. Kolita, appearing on behalf of Mr. T.R. Gogol, Standing Council of Housing Board.
All the
All the
respondents.
Standing Council, Assam State Housing Board, and others, Housing Board, appearing for the respondents has waited for some time to obtain instruction. Around 6 weeks since the respondents are represented by Mr. Gogol, no formal notice is required to be sent in this case. Extra copy will be furnished.
Item 10.
May it please your lordship. Your lordship, the petitioner is a charitable trust operating a charitable dispensary, and they have no other business or avenues. They are totally running on no profit basis. And the respondent herein had filed a complaint before the Assistant Labour Commissioner that his gratuity has not been paid. Ultimately, it was a contention before the Assistant Labour Commissioner that being a trust, we don't come under the ambit of establishment or employer under the Payment of Gratuity Act. As such, we are not liable to pay. And the further contention was that since we don't employ 10 employees, so we don't come under the act at all. And so we are not liable to pay the gratuity. Yes, though we engage part-time doctors, but part-time employees don't come under the definition of employee as also held by the Gujarat High Court judgment as well as Kerala High Court. So, but this contention was rejected and the Assistant Labour Commissioner held that we are liable to pay gratuity. Being aggrieved, we filed an appeal against the Commissioner. We paid the entire amount. Though the Assistant Labour Commissioner held that he has embezzled around 37,000, that amount has to be deducted and paid. But we paid the entire amount as a bona fide thing. Now, being agreed by Labour Commissioner also in a mechanical way, upheld the judgment of the order of the Assistant Labour Commissioner. So being agreed, we are before your lordship, because this issue has to be decided whether the trust which is operating on a charitable basis, this is charitable trust, whether they come under the purview of the act.
Will issue notice.
Lordship. If lordship, I pray, we have already paid the amount, your lordship. But I'm only praying if your lordship can stay the operation of this order, because otherwise we'll have other financial implication. Because the law is clear that charitable trust does not come under the purview of the establishment.
No, the order is to ensure that you make payment.
We have already
You already paid.
Yes.
So when is the question of stay?
I understand, but there will be other implications.
When you file a RA, what is the other? We have to know.
Yes. Yes.
There can be a invisible other
Yes. As and when the situation arises. Yes. Yes.
Mr. Asherman and council appearing for the petitioner, assuming the order dated, judgment in order dated
3/4/24. That's a Labour Commissioner at page 39.
But in your prayer portion, where is the mention of 3/4/2020? Where is it mentioned? 3/4?
Order.
1510 mentioned,
1510.
but the appeal was not challenged.
Appeal is 22-5. Sorry, Your Lordship. 22.
22-5. yes.
22-5.
In order dated 15/10/2022 passed in LPG case number 5/2021 by the Learned Controlling Authority under the Payment of Gratuity Act, 1972, as well as the order of the Appellate Authority dated 22/5/2024 passed in appeal number 01/2022, rejecting the contention of the petitioner. The instant writ petition has been filed. Mr. Sharma submits that pursuant to the direction issued by the Assistant Labor Commissioner, the writ petitioner has already deposited the amount. However, since a question of law arises in this case as to whether within quotes, being a charitable institution, the writ petitioner was liable to pay gratuity under the
Payment of Gratuity Act.
Payment of Gratuity
Act 1972.
1972. Question mark, unquote. Hence, unquote, which is required to be decided by this court. Hence, this writ petition has been instituted. Full stop. Mr.
J.K. Goswami, so 1 to 4 lordship. All the government.
Mr. J.K. Goswami, learned additional senior government advocate Assam, has appeared in accepted notice for respondent numbers, has appeared for report the issue notice returnable in 6 weeks. Mr. So-and-so, learned so-and-so has appeared in accepted notice on behalf of respondent numbers 154. As such, no formal notice is required to be sent to the state respondent. Extra copy of the writ petition from a requisite in numbers be furnished to Mr. Goswami so as to enable him to obtain instruction. Petitioner takes steps for servicing notice upon respondent number 5 by registered post with AD within a week from today. Heard on the prayer of interim relief. Since the petitioner has already deposited the amount, the question of granting any further interim relief in the facts of this case does not arise for now. However, if there is any further development in the matter wherein further demand is raised based on the impute orders, it will be open for the writ petitioner to approach this court by filing appropriate application.
Much obliged.
Seeking interim relief.
Obliged.
Item 11.
My lord, petitioner is the second wife of my husband
Why
expired.
are you so apologetic?
So, you know,
Petitioner is the second wife.
Yes, my lord.
Yes.
And my lord, my application, I have submitted application for disbursement of pensionary dues, my lord. And page 28 is the representation. And page 29, the department has forwarded my application to the authorities for consideration, my lord.
So what do you want? What do you want?
My lord, representation may be disposed of, my lord, in terms of,
But you don't want pension.
I want pension, my
Huh?
lord. I
What do you
want-
want? That's what I'm
And
asking.
the notice may be issued, my lord.
What do you want?
My lord, pensionary benefit of my late.
Can you get it? Is second wife recognized under the law?
My lord, as per full bench judgment, my lord,
Huh?
as per full bench judgment of our high court, my lord,
Which will be?
there is a provision, my lord. Though first wife is the entitled, legally entitled, but the department of its own volition can disburse the same to the other members of the
All
family.
right. So you want a direction that department on its own volition should
So
disburse the
consider,
amount.
my lord, shall consider, my lord.
Do you realize how fallacious this argument is? The court should direct it that department should voluntarily give it to you.
I have not received any benefit, my lord, even a succession certificate issued in our favor. Then
But
the,
the second wife is not entitled to
yes, my
anything.
lord, no, my lord. Even my lord, gratuity amount, leave encashment, GPF, though the learned judge, my lord, directed for disbursement to all the members.
Nothing can be done. We cannot create a chaos and confusion. The law is very straight and simple.
My lord, the other petitioner being legal heirs of the deceased shall be entitled to share of the debts and security. That will also not received, my lord. Page 20. As per the
Nothing can be done. You sort it out in the civil court. The department will have to go by the service record, service rules, service book.
and page 29 and 30, my lord.
Page 29, 49, 159, forget it. Second wife cannot get anything, so no mandamus can be issued. If no mandamus can be issued, why should we issue notice here?
My representation is pending, my lord.
They cannot allow your representation.
Page 29.
Mr.
there-
N. Sharma, land counsel for the petitioner, please for 2 weeks further time to examine the legal issues involved in this case and address this court as to how an application by the second wife for a share in the pensionary benefit of the deceased employees would be maintainable under the law. Full stop. Unless a case is made out by the petitioner on such count, it would not be permissible for this court to issue notice in this writ petition. Mr.
B das, my lord.
B. Das, land counsel for
For
the
APDCL, my lord.
APDCL as well as Mr. CKS Bureau, Lami Government Advocate Assam are present on behalf of the official respondent.
And
Mr.
Obliged.
Sharma,
Yes, my lord.
you have to stop this kind of petitions. How can we ask them to consider something which they cannot consider?
As per full bench decision. my
Full
lord.
bench decision, what decision is there? I am asking you. Has it been held that the second wife has a right?
No, no, my
Then
lord.
why are you relying on it?
My lord, if the department. Yes.
You don't have an answer. You just want to.
Item 12.
Well, please, Your Lordship. Here in this case, my lord, petitioner service was regularized. Only point is that whether his pension benefit will be considered under old pension scheme and new pension scheme. At this stage, notice is to go, my lord, let the government.
Mr. M.S. Sheikh, learned counsel for the petitioner. The issue raised in the writ petition is pertinent to the question as to whether within court the writ petitioner would be entitled to the benefit of the old pension scheme or would be covered under the new pension scheme. Question mark unquote. Mr. J.K. Goswami.
1 and 7, Lordship.
Senior Government Advocate Assam and Mr. A. Chandra was 6 and 8. Learned Standing Counsel Finance Department also have both prayed for some time to seek instruction. NOM 8 weeks. So and so, so and so. Who is for whom?
Lordship, I am from 1 and 7, Lordship.
1 and 7 and
6 and 8, Lordship.
6 and 8. As such, no formal notice is required to be sent to the state respondent. Extra copies of the writ petition be furnished to the learned Department Counsel so as to enable them to obtain instruction. Petitioner will take steps for service of notice upon the remaining respondent. Or his counsels.
Supplementary list promotion item 4.
Lord, I prefer
Not to
to,
withdraw.
yes, my lord.
Mr. A.Y. Chaudhary, learned counsel for the petitioner, seeks leave of this court to withdraw the writ petition. Prayer allowed, this writ petition stands dismissed on withdrawal.
Item 55.
May it please your lordships. Well, the petitioners, they are all direct recruit assistant engineers in the PW. They were recruited in 2022, Milas. And the private respondents number 3 to 98, they were all junior engineers. And there is a provision in the rule by virtue of which on acquiring that the B or BT, etc., they can be promoted as assistant engineer. However, the rule says that their appointment has to be construed as a direct recruitment, not as a promotion. The rule itself says, get up on the Possible kindly have rule 14 sub rule 4 clause C.
Who is appearing for the respondent?
Lordship, I'm appearing on behalf of Mr. P9 for PWD.
So it is to be treated as direct recruitment.
Rule 14.
11, Milord. 11 sub rule 4 clause C.
Yes.
And let's see, Milord. Then they are to be treated as direct recruitment. So admittedly, we were appointed in 22 and they are appointed in following promotion, they are appointed in 2023. So therefore, the question of
they, my lord, securing seniority over us cannot arise. Now, my lord, let us test it from another angle. Assuming, my lord, it's a promotion, then please come to rule 22(3). Assuming it's a promotion, then also they cannot get the benefit. Rule 22(3). A member appointed by promotion against a vacancy occurring in a year shall be senior to a member appointed by direct recruitment of that year. So year has been defined in the rules, my lord. Year has been defined in the initial portion, my lord, that is 2Z means calendar year. 2J. So, my lord, they having been appointed in 2023, there is no question. I'll just
So,
learn.
Credit has been given for their position as JE.
Yes.
Even after becoming AE.
Yes. Yes.
Is that what is
Yes.
happening?
Yes.
They are
No,
carrying.
no. Issue is on acquiring that degree, they become eligible to be promoted, or career progression is given by the rules, but that is to be treated as a direct recruitment. So we became a member of the service in 22. They became in January 2023. And year means a calendar year. Therefore, my lord, where is the question of they getting seniority over us?
So what is your grievance?
Now, grievance is, my lord, we are challenging the gradation list. Now they are purporting to undertake a promotional exercise. Now, if your lordship kindly comes to 102, that's the gradation list. Please come to 104, my lord. From 79 serial. From 79 to 174. From 79 onwards, there respondent number 3 to 98. Up to 174. And from 175, the petitioners. So actually what they have done, my lord, they have misinterpreted rule 22(3). Now, my lord, the law is absolutely clear. I'll just place two small paragraphs, my lord, from two judgments of the Supreme Court.
Private respondents are from which number in the seniority list?
175 onwards are the petitioners at page 107.
Arnab Barua.
Yes. Well, two small paragraphs from two judgments of the Supreme Court, my lord. First, my lords will have 1991 Supply 1 SSC 334, para 12. In the instant case, the promoted respondents 6 to 23 were not born in the cadre of the assistant engineer in the Bihar Engineering Service Class 2, para 12, Miller, at page 342. In the instant case, promoted respondents 6 to 23 were not born in the cadre of assistant engineer in Bihar Engineering Service Class 2 at the time when respondents 1 to 5 were directly recruited to the post of assistant engineer, and as such, they cannot be given seniority in the service of assistant engineer over respondents 1 to 5. It is well settled that no person can be promoted with retrospective effect from a date when he was not born in the cadre so as to adversely affect others. It is well settled by several decisions of this court that among the members of the same grade, seniority is reckoned from the date of their initial entry into the service. So these are all well settled principles. Now, other decision, my lord, 1994, Supply 1 SCC, one small paragraph, para 5, my lord. Para 5 at page 279. This court has examined the question of fixation of seniority interstate between officers appointed from different sources, that is by promotion and by process of direct recruitment. It is almost settled that while determining interstate seniority among the officers recruited from different sources or between officers appointed by the same process at different time, date of entering service is relevant. So these are the legal positions.
So your clients were appointed by direct recruitment.
Direct.
And in which month?
We were appointed, my lord, one second. We were appointed in, my lord, 21, 26/5/2020 and 21/9/22. 21/9/22. And they were appointed on 6/1/23. Next calendar year.
Though they are promoted, but as per the rules, it should be treated as direct.
Directly.
But by a misinterpretation of Rule 22.
2/3, my lord, they must have been given that benefit.
Lordship, kindly allow us some time, we'll obtain the instructions
So
and
I'm disposing out of right now. Till this inter-se seniority dispute is resolved by a speaking order, there will be no promotion from the grade of assistant
Yes.
engineer. You presume that the court will issue notice and you will get time. You made a wrong choice. Heard Mr. K. N. Chaudhary, I'm disposing it off. Is there any representation?
Yes.
Where is
There,
it?
yes, yes. my lord. Our representations are, my lord, at page 120. In fact, there are several, my lord. Page 86, page 93, then, my lord, page number 120.
So you file a fresh representation within 2 weeks.
We know a week's time, my lord. So many people are in.
Heard Mr. K. N. Chaudhary, and senior counsel assisted by Ms.
and Mahanta.
and Mohanton, and a counsel appearing for the writ petitioners. Also heard
A.
Ms.
Borthakur for P Nayak,
Whose name should I record?
Mr. P Nayak for PWD Lordship.
Mr. P. Nayak, learned standing counsel, PWD Assam, appearing for the respondents. Mr. The writ petitioners hearing are primarily agreed by the inter-se seniority list of assistant engineers, bracket civil, bracket close, in the public works roads department, bracket PWRD, bracket close, Assam. In the inter-se seniority list in the joint cadre of assistant engineer civil, public works road department, bracket PWRD, bracket close, and public works, bracket building and NH department, whereby the writ petitioners have been placed below the private respondent numbers 3 to
There from, my lord, serial number, 1 second, 10.
3 to
Give me a second, my lord.
3 to 98.
102.
3 to 98. Mr. Chairman.
Yes. From 79, my lord, to 174, the private
No,
respondent.
no, in the writ petition, respondent
Oh,
number
yeah, 3 to 9.
Yes. 3 to 90, below the respondent number 3 to 90. Mr. The basic contention of the writ petitioners, reduced to its essence, is that they were appointed as assistant engineers by means of direct recruitment in 2 batches, that is on 6/5/2020 and 21/9/2020. Thereafter, the private respondents who were serving as junior engineers.
My lord, I'm sorry, one thing, my lord. Not 6/5/2020, that was the advertisement. 21/9/22, my lord, all were appointed. 21/9/20.
In 2 batches, ma'am, were appointed as assistant engineer in the department on 21/9/2022 by means of direct recruitment. On the other hand, the private respondents who were serving as junior engineers, that is in a post below the writ petitioners hearing, were promoted to the post of assistant engineer by notification dated 6/1/2023 on by taking recourse to rule, which is that rule?
22/3.
No, that is seniority.
Or 11/4C, my lord.
Rule 11
4C.
of the Assam Engineering bracket PWD bracket close service rules, comma 1978 bracket below hereinafter referred to as the within course rules of 1978 bracket close on their acquiring the requisite academic qualification meant for recruitment, meant for direct recruitment of assistant engineer. Full stop. Next paragraph. Mr. K.N. Chaudhary, learned senior counsel appearing for the writ petitioners, has argued that as per the mandate of Rule 11 bracket 4, read with Rule 22 of the rules of 1978, the promotion of the private respondents to the rank of assistant engineer must be treated as direct recruitment for all intent and purpose. Full stop. In such an eventuality, since the writ petitioners were born in the cadre of assistant engineer prior to the private respondents, they would have to be treated as senior in service. Full stop. Under these circumstances, comma, submits Mr. Chaudhary, comma, the respondents, the departmental authorities have erroneously placed the private respondents above the petitioners in the gradation list of assistant engineers by giving them undue credit of their tenure of service as junior engineers, although such a recourse was clearly impermissible under the rules. Full stop. Mr. Chaudhary has further invited the attention of this court to the provisions of Rule 2J. Rule 2J, defining within quotes year, YER, unquote, to mean a calendar year, and submits that since the writ petitioners were appointed in the year 2022, they ought to have been given higher seniority over those departmental candidates who have been born in the cadre in the succeeding year, that is in the year 2023, such as the private respondents. Full stop. Next paragraph. Mr. Chaudhary has further submitted that after publishing the erroneous gradation list, the respondents are contemplating to promote the departmental candidates to the next post of
Assistant Executive Engineer.
assistant executive engineer. If the said process is allowed to go ahead based on the impugned gradation list, then in that event, the same would cause serious prejudice to the interest of the writ petitioners. Full stop. The learned senior counsel has further submitted that repeated representations submitted by the writ petitioners ventilating their grievance on the aforesaid aspect of the matter has failed to evoke any response from the authorities, as a result of which the petitioners have been compelled to approach this court by filing the present writ petition. Mr. Chaudhary has therefore prayed for an interim order restraining the respondents from considering the assistant executive engineers for further promotion during the pendency of this writ petition. Stop. Mr. Nayak, learned departmental counsel, on the other hand, submits that if the petitioners are aggrieved by the gradation list published on so and so, the departmental authority would certainly examine their grievance in the light of the rules, and therefore there is no necessity for this court to pass a restraint order halting the process of promotion at this stage. Full stop. Uh, I have considered the submissions made by learned counsel for both the sides and have gone through the materials available on record. After examining the scheme of the rules of 1978, more particularly the provisions of Rule 11, bracket 4, bracket close, as well as Rule 22, bracket 3, read in the light of the observations made by the Honorable Supreme Court in the case of State of Bihar and others versus Akshori, Sachindranath and others, reported in 1991, Supplementary 1 SCC 334, para 12, as well as in the case of Bhe Ram Sharma, BHEY, Bhe Ram Sharma and others versus Haryana State Electricity Board and others, reported in 1994, Supplementary 1 SCC 276, para 5. I am of the view that the petitioners have made a strong prima facie case in their favor. However, since the question of fixation of inter se seniority is a matter which is primarily required to be examined by the departmental authorities, and considering the fact that keeping the writ petition pending before this court with an interim order operating therein might prejudicially affect the interest of the departmental candidates as well as the department itself if there are vacancies available at the higher grade. With the consent of learned counsel for both the sides, this writ petition is being disposed of by granting 2 weeks time from today to the writ petitioners to submit a fresh representation before whom?
Before the chief engineer, Miller.
Before the, is he the authority to determine?
Oh, no, I think it's appointing authority is government. I'll write to the secretary PWD.
Commissioner and Secretary, PWD, Assam, by enclosing a certified copy of this order. If such a representation is submitted within 2 weeks from today, as permitted by this court, the grievance of the petitioners be looked into and the same be disposed of by a reasoned order. First of whatever be the outcome of the process, the petitioners be communicated of the same in writing. First of until such time the aforesaid exercise is carried out and completed, no further promotion from the cadre of assistant engineer in the joint cadre of PWD so and so shall be given effect to. With the above observation, this writ petition stands disposed.
Deeply. If your lordships would have accepted my learned friend's request, we would have stand to gain. Miller.
That's what she also thought. Sometimes personal losses are understandable.
For admission, item 13 and
May it please your lordship. My lord, the matter pertains to my lord family pension. The husband of the petitioner was appointed, my lord, in the year 1987, my lord. And thereafter his service was, my lord, approved in the year 2005 and subsequently, my lord, regularized. My lord, regularization, my lord, order is at page 37, my lord, of additional affidavit, page 37. My lord.
Is this covered by Sangeeta Roy?
Yes, and also your lordship has passed another judgment, same, my lord, from the similar, my lord, list. Bijon Hafila, my lord. Same, similar, from the same. Bijon Hafila's name is at page 44, my lord. And my lord number is at page, at serial number 9, my lord.
So your case is covered by this judgment.
Yes, ma'am.
Lordship, his appointment was later, his regularization was later on cancelled by the finance department, Lordship. We are stating in our affidavit, I am for Dimahasa, Lordship, he had joined in 87.
Yes.
Then he was regularized, but later on finance department has cancelled his regularization.
Where is the order of cancellation?
Lordship, we have not annexed it, but I have stated in our affidavit in paragraph 8, Lordship. It is in their additional affidavit, Lordship.
Whose additional affidavit?
Petitioners.
Have you challenged this order of cancellation by finance department?
My lord, that was not served to me, my lord. And as per Mahendra Singh Gill, my lord, case, my lord, I was regularized in the year 2005, my lord.
No, see, have you challenged?
I have not aware, my lord, about that.
Now also you are not aware.
Yes, my lord. Subsequently, I have filed, my lord, this. And they in their affidavit, my lord, they have mentioned that
Mr. Karkar, this here and there will not work. Have you challenged? If you have not challenged, I can dismiss your petition, but I will not do it. You need 6 weeks time to challenge it, you do it. Rest of the arguments will not work. If you have not challenged the order by which your regulation has been cancelled, how do you expect the court to grant you?
If your lordship see their affidavit, my lord, they have talking about another, my lord, my cancellation, my lord.
All right, then you argue. But on that ground, your petition might be dismissed. Argue. No, my lord.
The lordship may allow me, my lord. 6.
No, you argue. An order which is coming in the way of relief, you are not ready to challenge it. What kind of advocacy is this?
Yes, my lord.
Huh?
I may allow my lord.
Now, when I said I'll dismiss, then you have said. Absolutely unethical. On the prayer of petitioner's counsel, these matters stands adjourned for 4 weeks so as to enable him to obtain instruction and assail the order dated. Order dated 10 February 2006, by means of which the Finance Department of the Government of Assam had cancelled his order of regularization in service. Let the matter be listed accordingly. You have to challenge that, otherwise how will we ask them to answer?
Name may be recorded, ma'am.
So appears to be respondents.
Item 14 and 15.
And 3 of them would be amended.
Wait, please, Your Honor. My lord, the respondent has not filed affidavit, my lord, till date. Till date, there is no affidavit filed by the respondent, my lord. Earlier 2 occasions, they have taken time, my lord. And my prayer is for my pensionary benefit and other.
Where is the order?
Lordship may kindly see page 43, my lord. This is the 3rd round of litigation, my lord. 43, my lord.
Lordship, at 45, the effective
No, order of the court.
Oh, yes, my lord.
order of the court in the initial.
This is writ petition or contempt case?
Oh, my lord,
This is
subsequently.
writ petition, Lordship.
This is
14 is writ petition.
writ petition. During the pendency of the contempt petition, they have filed the impugn order, my lord.
So speaking order has been passed.
Yes,
Yes,
Lordship.
So contempt case, nothing survives.
Yes, Lordship.
So you write in that. I had Mr. G. Uddin, learned counsel in the contempt case, learned counsel for the petitioner. Also heard Mr. D. Upamanu, learned counsel appearing for the respondent, who submits that the departmental authorities have issued speaking order dated 4/1/2022 in compliance of the order of this court, and therefore nothing survives for adjudication in this contempt case. Mr. Uddin has not also not disputed the same position, but has added that the order dated 4/1/2022 has been assailed by the petitioner by filing writ petition number 3991 of 2022, which is pending disposal before this court. In view of the above, contempt case number so and so stands closed. Now come to the writ petition. What is
Yes,
it?
my lord.
Lordship, here, Lordship, we are yet to receive instruction, Lordship. No affidavit has been filed.
But how long can you, this is a matter of
Yes, my lord.
pension.
Yes, Lordship.
My lord, since my lord, 2003, my lord, he was before this honorable court, my lord, and subsequent, my lord, this honorable court passed earlier order also, my lord, regarding salary.
Yes, so argue your case. Argue.
Oh, yes, my lord. Lordship may kindly see, page 43 is the impugn order, my lord. My lord, gist of the impugn order that my lord, I have served 15 years of continuous service, my lord. And thereafter, there is a break, my lord, which I stated that, my lord, I was on leave, my lord. But they are saying that this was my unauthorized absence. That is why, my lord, invoking rule 64, they have rejected my whole claim. But
Please read the order 4/1/2022.
yes, my lord. Regarding release of pensionary benefit to Dr. Pradeep Bhattacharya in view of the Honorable Guwahati High Court order dated 16/2/2016 in writ petition number 2724/2024. Order of the Honorable High Court on 16/2/2016 in WPC number 2724/2024. Findings. Dr. Pradeep Bhattacharya was appointed as MHO 1 on ad hoc basis and posted at epidemic unit Karimganj, filed notification dated so and so, dated 21/1/1988. Second, thereafter he was transferred and posted as urban health officer Karimganj, filed number so and so 26/5/1993 with an additional charge of ex officio register of births and deaths Karimganj municipal area. Dr. Bhattacharya applied for leave with effect from 30/10/2003 to 31/12/2008 and continued to submit
leave petition up to 31/12/2008. Dr. Bhattacharya did not join his duty even after expiry of his leave. There are also no official record of his leave being granted to him or any authority slip for drawal of leave salary received from AG. Dr. Bhattacharya was promoted to the rank of Senior M and HO and posted at Katlichira, CHE by order number so-and-so dated 12/11/2008, and on receipt of the same, he submitted a petition for modification of his place of posting to Karimganj CH instead of Katlichira CHC. Dr. Bhattacharya filed a writ petition number 2724/2014 before Guwahati High Court for non-payment of the pension to him after his superannuation on 31/7/2013. Honorable Guwahati High Court passed an order on 16/2/2016 in a writ petition with following direction. This writ petition is disposed of with a direction to the authorities to process the pension papers of the petitioner with effect from 31/7/2001. The Health Department shall also take a decision as to manner in which they are going to treat the break in service period of the petitioner with effect from 7/6/2003 till 31/7/2013. The above two directions are subject to the condition that the petitioner had not been terminated or dismissed from service on the basis of any departmental proceeding which had been initiated and completed prior 31/7/2013. The entire exercise of directed shall be completed within a period of 3 months from the date of the receipt of the certified copy of this order. Dr. Bhattacharya also filed contempt petition number for disobedience of order dated 16/2/2014. Views of Judicial Department was sought on the matter and their views is quoted below. It appears that initial appointment of the petitioner was on ad hoc basis, followed by the subsequent transfer and posting. Precise disclosed that he remained in service January 1988 to October 2003 for a period of about 15 years and thereafter terminated, remained unauthorizedly absent till his normal date of retirement, that is 31/7/2013. Normally, such unauthorized absence entails dismissal after holding a DP, but no DP having initiated earlier, it cannot be started now. It is further noticed that the petitioner did not join his promotional post and thereafter he was holding the earlier post till 2013. Therefore, the department may ascertain whether service of the petitioner was subsequently regularized or brought in substantive capacity. If not, he is not entitled to pension. In that event, the department have to go for appeal or review. Otherwise, the department may comply with the instant order that is 16/2/16 first in WPC number 272414 and process the pension papers with effect from 31/7/2013. Since the petitioner did not serve during the period since 2003 to 2013, his period of absence may be regularized by way of leave without pay. This may arise the occasion for granting pension from 2013. Therefore, the department may explore possibility of granting pension on the basis of last pay drawn or proportionate pension in consultation with the P and PG department. However, if it is found difficult to implement the order, the department should go for appeal review. In the fact of the present case, the petitioner also utterly failed to report for duty and therefore he does not deserve any further consideration for normal retirement benefit. The department may examine the whole matter in the light of the above and take appropriate decision. No departmental proceeding was drawn against the Dr. Bhattacharya as per office record available. Views and PG department on the case is quoted below. P and PG department observed that the concerned government servant Dr. Bhattacharya retired M and HO1 had rendered 15 years approx of service prior to his unauthorized absence from the duty for more than 10 years. Due to his unauthorized absence, his past service are forfeited in terms of Rule 64 of ASP Rule 1969, and due to this condition, he is not eligible for pension. Views of the Finance Established Department on the case is quoted below.
it is appears that Honorable High Court directed the authority to process the pension papers of the petitioners with effect from 31/7/2013 and to take a decision as to the matter in which they are going to be treated. The break in service period of the petitioner with effect from 7/6/2013 to 31/7/2013. If you on private granted is granted by relaxation of provision of efforts and assets to regularize the period with effect from 7/6/2003 to 31/7/2013, then the period till not count for pension as Pension Rule 1969. Hence, the department is requested to consult the matter with the Personnel PG Department for relaxation of minimum qualification services of pension for compliance of the Honorable High Court's order dated 16/2/2016, passed in WPC number 2724/2014. Therefore, views of Personnel and PG Department was sought again, and their views quoted below. Pension and Public Grievances Department, after observation of the Personnel proposal express its inability towards the relaxation of minimum qualification service of pension beyond 1 year. After careful consideration of all the relevant records of the matter, it appears that Dr. Bhattacharjee was unauthorizedly absent from 7/6/2003 and did not show any intention to work as well as to his promotional till his normal date of retirement on to 31/7/2013. Although no departmental proceeding was drawn against the doctor for his unauthorized absence, but not initiating departmental proceeding should not make such a person eligible for pensionary benefit. Also, the doctor did not complete the minimum qualification service to become eligible for pension. Therefore, keeping in the view with the order of the Honorable High Court dated 16/2016 in WPC number 2724/2014, and taking into consideration of the views of the concerned department, the Government in Health and FW Department is pleased to dispose of the instant case with the following order. The Government in Health and FW Department expressed his inability to grant pensionary benefit to Dr. Bhattacharjee, retired urban health officer, Karimganj. So this is the order, madam.
So, your client has remained absent since 2003 till 13. That
Well,
you are not disputing.
but there is no
No, just a
department.
minute. These facts,
In 2008, my lord, he was promoted to next promotional post. 2008, my lord.
Mhm.
And thereafter, my lord, he was in some, my lord, in some course regarding the, my lord, training course, my lord.
Mhm.
And before that, my lord, since
So
2003,
where is the statement that from 7/6/2003 to
Last-
31/7/2013, the
Last-
petitioner has continuously discharged his service without any break? Where is that statement?
my lord, which statement, my lord, from?
Gap period. 2003 to 2013.
Last to be kindly see page 12, my lord, para 15.
Yes.
My lord, that the petitioner further beg to submit that as regard to the period of service from October 2003 to till the date of the retirement on 31/7/2013, the petitioner applied for unleave and same also granted up to 31/12/2008. And within this period of time, on 12/11/2008, he was promoted to the rank of senior medical health
All right,
officer.
so you were granted leave till 31/12/2008.
Yes, sir.
What happened thereafter till retirement?
After retirement.
On the prayer of Mr. Diuddin, I counsel for the petition. Now, on the request of Mr. D. Kamini, non-standing counsel, Health Department, Assam. This matter stands adjourned for further 4 weeks, so as to give one final opportunity to the respondents to file counter affidavit. Mr. Diuddin, learned counsel for the petitioner, as well as Mr. D. Bhattacharjee, learned standing counsel, appearing for the Office of Accountant General A&D Assam, are present. You are not answering the questions.
Lost it. I understood.
And there are problems here.
He was
You
before
should have preferred a review. Why haven't you done it?
Lordship,
Recall the order in the contempt case. That don't type it along with contempt case numbers. There would be a contempt on that. So next day things are going to be difficult. No review has been filed.
Yes, sir.
Of course, the learned judge also did not go into all these details. But whatever is mentioned in the order, the department secretary has clearly said that you should have asked for a review or modification of that order.
Yes, Lord.
It's almost saying that High Court has given a direction, we are rejecting it. Content on that. So this will be final opportunity for filing affidavit both in read petition as well as contempt petition.
Obliged.
Obliged.
Contempt is not disposed of.
Yeah, please, your lordship. This is the second round of litigation, my lord. I have not been paid my arrears salary and other constitutional benefits. They've been seeking time only, your lordship.
Process.
Yes.
नहीं heavy already मैंने heavy तो direction तो दिया government के direct करो direction of litigation after receipt of the sanction, lordship, it is under process, lordship. He will get the arrears salary, lordship.
How long will it take?
So far, my instruction, lordship, is stated that it is under process, lordship. Lordship, lordship.
Yes.
Sometime is
How
required.
much time? Day after tomorrow?
No, after vacation, lordship.
This is arrears salary. Current salary has been paid.
I have already read, lordship, and I've been paid my provisional pension for time being now. I am a lordship very ill person. I would do my treatment. I am suffering.
Well, before vacation. Before vacation.
Lordship,
Mr. So-and-so learned counsel for the petition also are Mr. J.K. Goswami, learned additional senior government advocate also, who has produced a copy of the communication dated 30/8/2024, issued by the Joint Secretary to the Government of Assam, Women and Child Development Department, addressed to the Director, Women and Child Development, Assam, Guwahati 6, to submit that after receipt of the sanction for release of the arrear salary of the petitioner for the period claimed by him, certain clarifications have been sought from the office of the director. However, according to Mr. Goswami, the arrear salary of the petitioner is under process and shall be released within a short period of time. On such ground, the learned government advocate Assam has paid for further 3 weeks time to obtain instruction. Where I allowed as last opportunity, let this matter be listed again on 3rd October.
If end of October, it may come up after vacation also.
At least after immediately on reopening of Puja vacation.
Date will fix up envelope.
Item 18 and 19.
Mr. B. Chakravarti, learned standing counsel.
Respondent number 2.
Respondent number 2 is present.
May it please the lordship. My lord, before I proceed, my lord, may I just make a request, my lord? Can item number 19 be taken up first, my lord? Because in 19 they have filed an affidavit, my lord. My lord, on last few occasions, my lord, in fact, in pursuant to an order of the Honorable Court on 7th of June 2024, direction was given to the state level recruitment board council, my lord, to produce the marks obtained by the petitioners in this recruitment process vis-a-vis, my lord, the merit list where they stand in the merit, my lord. Basically, we are my lord, agrees by the fact that we had participated in a recruitment drive of 2022, my lord, for the post of, my lord, class 3, my lord, grade 3 post, conducted by the Assam State Recruitment Commission, my lord, which is a statutory body created under the Act, my lord. That is, my lord, the analogous post grade 3 and grade 4 rules and Act, my lord. So now we have participated and we have fairly performed well, and we have, my lord, cleared the first stage, that is the stage of written examination, and we were called for, my lord, computer test, my lord. Now, what happened after computer test was over? As per the mandate of the rules, they were required to publish the list of the meritorious candidates, and the merit list was to be published, showing the name of all the candidates who were to be recommended to the government for appointment, my lord. Now, without publishing this merit list, my lord, the authorities have given us a letter communication saying that your cases were rejected, my lord. So on that particular communication, we came before this court, my lord, challenging that, saying that the ground they have given by them is perhaps, my lord, is contradictory to the provisions of the rules, my lord. They were at first required to publish the merit list so that we knew where we stand. Now, in between, my lord, we have done some RTI. So under the RTI, we came to know that we have crossed the cutoff marks in the first, my lord, examination, that is stage 1. So therefore, we were called for the stage 2. Now at stage 2, they were required again to give a cutoff marks. Till date, they have not given. So on the last occasion, this court, my lord, have passed this order saying that you bring the records and show where we stand, my lord. This is in brief, my lord, the background of this.
Who is supposed to produce the record?
My lord, the counsel appearing for the state level recruitment board, Mr. Chaudhary, Bikram Chaudhary. My lord, it was the counsel who appeared on behalf of the state level recruitment board, my lord. Order dated 7/6/2024, before lordship.
That is name been shown.
My lord, that is one difficulty. My name is not shown, my lord, in the causes, my lord.
My lord, B. Chaudhary is not available here as today, my lord. So maybe another day, my lord.
My lord, this second round of recruitment process just concluded yesterday, my lord.
We'll act on Thursday then.
As a lordship pleases, my lord.
Mr. H. Buragal and counsel for the writ petitioner in both these writ petitions are present and has invited the attention of this court to the order dated
7/6/2024, my lord.
7/6/2024.
2024, my lord.
2024. Passed in this batch of writ petitions. To content, passed in item number,
All the cases, my lord, they are analogous, my lord.
passed in these cases, requiring the learned standing council SLRC to produce the relevant records. However, Mr. B. Chaudhary, learned standing council SLRC is not present before this court today. It appears that his name has also not been reflected in the cause list. Mr.
U. Sharma.
Mr.
U. Sharma for Secondary Education Department.
Mr. U. Sharma, Learned Standing Council, Secondary Education Department, Assam, and Mr. T.K. Roy, Learned Standing Council for the SEBA are however present. Full stop. Since the direction to produce the record was issued to the Learned Standing Council SLRC, and considering the fact that his name is not shown in the record today, this court is not left with no option but to adjourn the matter. First of since Mr. Buragwa has expressed extreme urgency in this case by contending that the recruitment process is proceeding at a fast pace, the registry is directed to list these cases again on Thursday, date to the 19/9/2024 as fixed items by showing the name of Mr. Bikram Chaudhary, learned counsel for the respondent.
Respondent number, he is, my lord. 5 and 6, my lord.
Respondent numbers 5 and 6 in the first list.
I'm on next to
Item 20.
Made with lordship. 20 also similar order would follow, my lord.
So 18, 19, 20.
20, my lord, same order. I'm much obliged, my lord.
Item 21.
Yes.
During service period, 1 month salary is somehow not paid. And he retired 20. After that 21, he applied and his application also forwarded page 10 in XRA to considering an additional budget. That was not done. Only 45,000 salary, my lord. That was somehow not.
Salary for which month?
February 17.
And he retired when?
20.
What 20?
2020, 3/11/2020.
Huh?
3/11/2020.
Retirement only normally happens on the last day or the first day.
Yes.
of the month.
30.
Huh?
It is 30/11/2020. 3, not 3. 30.
Yes, what do you have to say?
Lordship, otherwise, and after 3 years, he come to the court. Retired on 20, he filed writ petition 2023.
But you, if
Some
you have
delay.
not paid him his salary.
Yes, yes, but I have communicated to the department. Department said that we have sent the proposal to the government because of
Department means whom?
health department, Lordship.
All right, I heard Mr. M.J. Barua, learned counsel appearing for the writ petitioner. Also heard Ms. S. Sharma, learned standing counsel, Health Department, Assam, appearing for the respondents. First up,
All the times.
the writ petitioner hearing has retired from service as non-medical supervisor, bracket NMS, bracket close, working under the office of the Joint Director of Health Services, Morigaon, with upon attaining his age of superannuation with effect from 30/11/2022, 2020.
20.
After his retirement, the petitioner is receiving pension on regular basis. First up, the only grievance of the petitioner as agitated in this writ petition is that for no valid reason, the authorities have not paid him his salary for the month of February 2017, amounting to rupees 45,145. Full stop. This writ petition is therefore instituted, seeking a direction upon the respondents to pay him the salary for the month of February 2012, along with interest at the rate of 9% per annum, calculated on the unpaid dues with effect from February 2017 till realization. First step. Ms. Sharma, learned SC, Health Department submits that as per instructions received by her from the
On Director of Health Services.
Director of Health Services, Mama Hangrawari, the
Yes.
proposal for release of the petitioner's salary has been sent to the government and the matter is currently under.
Lordship, a date is there.
Has been sent to
Director
the-
has submitted area proposal to the government on 7/3/2020.
Has been sent to the government on 7/3/2020.
7/3/2020.
2020. However, the matter is pending with the government
Yes.
since then. Full stop. The departmental authorities have not filed any affidavit contesting the prayer made in the writ petition. Next para. On the contrary, it appears that the Director of Health Services, that is the respondent number 2, has forwarded a proposal for release of the salary, area salary to the petitioner for the month of February 2017. Full stop. There is no explanation as to why, despite receipt of the proposal, the amount has not been released till today. Under the circumstances, this court is of the opinion that no practical purpose will be served by keeping this writ petition pending before this court any further. Full stop. The writ petition is therefore being disposed of with a direction upon the respondent number 1 to examine the grievance of the petitioner as well as the proposal dated 7/3/2020 sent by the Director of Health Services and thereafter take necessary steps for release of the area salary of the petitioner for the month of February 2017 if the same is found to be due and payable to him. Full stop. The Finance Department to the Government of Assam shall render necessary cooperation in the matter in accordance with the rules. The direction issued herein above be complied with within a period of 3 months from the date of receipt of the certified copy of this order. Writ petition stands disposed of accordingly.
Obligation.
Item 22.
It is a lordship. Also, matter pertains to lordship non-payment of pension lordship. On the last two occasions also lordship, the respondent are directed to file the affidavit. That has not been done yet, lordship.
Lordship, on 19/4/2023, the executive engineer Barthelaxa division has already submitted the pension papers to the chief engineer irrigation, Lordship.
When did the petitioner retire?
Lordship, 31/12/2022, lordship. Till that, he is not receiving anything, lordship.
Why it takes so long to settle pension?
Lordship, we
Is
have
it
already
become a trend in
submitted,
the state?
Lordship, we have already submitted the pension papers to the chief engineer irrigation, Assam, Guwahati. On 19/4/2023.
As far as gratuity has been paid, madam.
Sorry?
CPF amount has been withdrawn. CPF amount has been sanctioned, my lord, as per instruction.
No, pension.
Yes, my lord, petitioner is a works as employee, my lord. So he cannot be regularized as per Omadi and Upenda's case, my lord. So, my lord, and the terminal.
He's not entitled to pension.
Yes, my lord.
Have you filed any affidavit taking
my
that
lord.
stand? Then you have
I
to take a stand in the affidavit.
Yes, your lord.
Heard Ms. M. Nerula, and counsel for the writ petitioner, also heard Ms. D.S. Neogi, learned standing counsel irrigation department, Assam, who submits that the GPS amount payable, GPF amount payable to the petitioner has already been released.
Yes, my lord.
However, since the petitioner's services as work charge employee
Yes, my lord.
was never regularized, hence he is not entitled to receive any pension. The learned standing counsel irrigation department prays for 3 weeks' time to bring the said stand of the department on record by filing affidavit. Ms. S. Kemprai, learned standing counsel. So-and-so is also present, along with Mr. R.P. Talukdar, learned standing counsel, AG, A.N.E. Assam are present on behalf of the respective clients.
Deeply obliged.
This is the matter accordingly.
Item 23.
Yeah, please. My lord, this is regarding pension, my lord. Due to mismatch of the names, my lord, my pension has been stopped.
Mismatch of
Name, my lord, in the bank and the treasury record, my lord. My name is Khadija, my lord, and treasury forwarded, my name is Khudaja. That is the problem, my lord.
Treasury Assam.
Silchar, my lord.
Who is for the finance? Mr. Nayak, what is it? Is it correct?
Not because of the government lordship. In fact, in bank documents, her name is different, and in her pension paper, her name is different. That is why bank objected and stopped her pension lordship. Now it is for her to go before the bank and establish that she is one and the same person lordship.
My lord, bank has not given anything. My lord, I have already given.
No,
my lord,
everything is
one
in the
affidavit,
bank
my
lordship.
lord.
These days, only
The
the
bank, we'll have to ask the bank.
My
why
lord,
they are-
only the first pension is released by the department. Remaining lordship, all by the bank lords.
All right, you take down, heard Mr.
F.A. Lasko, my lord.
F.A. Lasko and counsel for the petitioner who submits that although the petitioner is entitled to relief pension or family pension,
Family
Family
pension.
family pension, the same has not been released by the bank till today. Full stop. Mr. P. Nayak, learned standing counsel, Finance Department, Assam submits that the department has already sanctioned the family pension. However, due to a mismatch of the name of the petitioner in the official documents as well as the bank account, it is which bank is it?
My lord, State Bank of India, Arunachal branch, Kachar, my lord.
The State Bank of India, Arunachal branch, Kachar, has stopped the release of the family pension on such technical ground. Therefore, submits Mr. Nayak, the department does not have any role to play in the matter. Is that you don't have any role to
No,
play?
if any clarification is sought from our side,
Therefore,
we'll definitely.
submits Mr. Nayak. If any clarification is sought in the matter from the Treasury Office, the same will be issued. Full stop. Be that as it may, taking note of the submission of Mr. Nayak, petitioner is granted 2 weeks' time to file appropriate application for implement of the State Bank of India, Arunachal branch as a party respondent.
Party here, madam.
Then who is appearing for the State Bank?
Respondent 5 and 6.
Anybody is appearing?
Officer for us. So what matter for affidavit, he has filed affidavit also.
Be that as it may, Nalage. The State Bank of India and the manager and the branch manager have been, the manager and the branch manager of State Bank of India of the concerned banks have been implicated as respondent numbers 5 and 6 in this writ petition. However, the learned counsel for the respondent numbers 5 and 6, namely Mr. N. Borua, is not present before this court today. In view of the above, let this matter be listed again in the next week, so as to enable the learned counsel for respondent numbers 5 and 6 to remain present in the matter. You also inform me with requisite instruction. You inform them.
Madam.
Made please, your lordship.
I am the respondent number 5, my lord. 2 weeks' time may be granted for filing rejoinder, my lord.
Rejoinder
My lord,
or counter affidavit.
counter admitted.
What is this matter about?
Lordship, the only issue to be second round of litigation, the only issue is to be decided is whether the date of birth of an employee can be decided on the basis of Aadhaar card or PAN card, or it is the school certificate, your lordship. On the basis of wrong date of birth mentioned in the Aadhaar card, your lordship, they have superannuated me from my service, although I have 8 years of service left.
Wrong date of birth recorded in other card.
Aadhaar card, which has, however, in the meantime been rectified by the petitioner. But they have not considered the
Respondent number 5.
I'm newly appointed in Bhuvanabadi helper, my lord.
Achha, in your place,
My lord. After retirement, my lord, advertisement is issued, my lord, appointed me, my lord.
yes, what do you say? He wants 2 weeks' time to file. Let it come after vacation, we'll decide. Mr. M. Heard Mr. M.H. Lakshman, learned counsel for the writ petition, also heard Ms. M. Bhattacharya, learned additional senior government advocate Assam, appearing on behalf of the respondent numbers 1 to 4 in this case. Mr.
M. Hawk.
M. Hawk, learned counsel for the respondent number 5, praise for and is granted 3 weeks further time as last opportunity to file affidavit. List this matter for admission hearing again after the Puja vacation.
lordship a date, kindly fix a date, your lordship.
Will come after Puja.
Oblige, lordship.
May it please your lordship. Here, my lord, the cases of removal from service, my lord, in the Central Bank of India. On the ground, my lord, that some,
So you are for respondent numbers 1 to 4.
Yes, your lordship.
This is a order of removal from service.
yes. Only, my lord,
Compulsory
that,
retirement, your lordship.
Compulsory.
only, my lord, there is one interim prayer I want to make, my lord, that is substance allowance for 4 months has not been released. Substance allowance during the period of my lord, this inquiry, that is pending. And my gratuity and my leave expense. The rest, your lordship will hear after some time.
For your lordship, for gratuity and the leave encashment, they have to make a proper application in the concerned branch. And as far
Because
as the
they
subsistence
have
allowance, I have to take
but
instructions.
they
Your
have
lordship.
blocked it. They have deposited the amount, but they have blocked it. So I am not in a position to do it.
So subsistence allowance
Yes, your lordship, I'll
for
do
4
take.
months. Is it for 4 months?
4 months.
Your lordship,
Tell us.
yes, yes, yes.
Next-
I'll do
next
definitely.
week.
Yes, next week, your lordship, maybe
On
come up on.
26th, my lord.
Yes. Mr. R.P. Sharma and a senior counsel for the writ petitioner submits that besides the other grievances expressed in this writ petition, the petitioner is also aggrieved due to the fact that subsistence allowance for a period of 4 months pertaining to the period when his client was under suspension have still not been paid to him for no valid reason. Wisdom.
And
gratuity and
gratuity and leave encashment.
That apart, even the gratuity,
Your lordship, for gratuity, they have to
his submission we can record.
Yes.
Gratuity and
leave encashment.
leave encashment amount due and payable to the petitioner, despite the order of penalty of compulsory retirement, has also not been released to him till today. First of Mr. M. Sharma raised for time till 25/9/2024 to obtain instruction and appraise this court as to why subsistence allowance, gratuity and leave encashment amount due and payable to the petitioner cannot be released by the bank authorities even during the pendency of this writ petition. First of let this writ petition be listed again on 25/9/2024 as a fixed item by showing the name of learned counsel for both the sides. In the written. In the public.
Item 26.
Yeah, lordship, I need some time to get instruction, lordship. Some time, lordship, to get the instructions, lordship.
What is this matter about?
The recovery of my salary for due to her stay in service.
There is a stay order.
Hello?
Stay order is there. Is there a stay order?
No, but already recovered, my lord. Already, my lord has deducted.
Right, we'll give him, we'll have it after vacation.
Lordship.
The last chance, my lord. There's so many.
Mr. A. Khanikar, learned counsel is present for the petitioner and expressed urgency in the matter, since there is no interim order operating in this case. Mr. N. Upadhyay, understanding counsel litigation department, however, seeks 4 weeks further time as last opportunity to obtain instruction and file.
Lost.
Mr. P. Nayak, understanding counsel finance department, Assam, and Mr. Assam, Mr. J.K. Goswami, learned additional senior government advocate, Assam, for the pension and public grievance department, and Mr. D. Bhattacharya, learned standing counsel for the Office of Accountant General bracket A&E Assam are present. On the request of Mr. Upadhyay, this matter stands adjourned for 4 weeks so as to enable him one last opportunity to file
Lost.
list of order. None appears to the petitioner on call.
The petitioner before your lordship is a regular master will worker. After rendering my lord more than 25 years, and out of that, my lord, more than 11 years regular service, he retired, my lord. And therefore he is paying pension.
Regular service only 11 years.
11 years, more than 11 years.
More than means what? How many more? Another 11 years.
No, my lord, total 25 years. And regular service is 11 years.
Only 20 regular service will count,
Yes, ma'am.
and that has to be 20 years to receive
But
pension.
my lord, there are judgment of this one I will quote. And
Which
I have
says what?
saying that, my lord, if regularized, my lord, then pension should be given, my lord. Lordship kindly will look.
Regardless of whether he fulfills the number
Yes,
of
yes,
qualified years.
yes.
Where is the judgment?
My lord, I have annexed, my lord, relevant portion, page 51, my lord. Paragraph 31, my lord.
So it is written minimum 20 years.
Yes, my lord.
You are saying 11 years.
No, total 20 years, my lord. I have, my lord, total 25 years.
Yes,
And, my lord,
Mr. Nayak,
and by implementing that, my lord, one circular is also there, my lord, page 25 is there.
The judgment is there, if the total period is not 20 years, then the period from work order must have will be taken account of. But subsequently, Lordship, Supreme Court passed one judgment, there it has been stated that only the deficit period will be taken. And will calculate. So otherwise, also if his total period is 20 years, then he is eligible.
He says 25 years, yes, sir.
But you will verify.
All right.
I'm for accountant general.
We'll ask them to verify. And
Verify and had to your lordship pass an order because what happened, Sanjita Roy case, that particular case, though it decided, then thereafter, it was sent to PPG department. PPG department for that particular case, it was been sent, told that, okay, it will this amendment is to be there because earlier 26 years deduction. That is to be modified as part of Sanjita Roy case, but it will take time. Therefore, time being, for these petitioners, for particularly Sanjita's petitioners, may be allowed. Thereafter, they have not amended so part of timing taken, but another clause is given for me instruction. If court pass order, we'll do it accordingly. Honorable court pass an order. That is our stand earlier occasion. Then I clarified that.
all right, heard Mr. M. Borbuya, learned counsel appearing for the writ petitioner, also heard. We'll go serially, huh? Also heard Mr. Who is the standing, Miss M. Kalita, learned standing counsel, PHE department, appearing for response numbers 1 and 5. Mr. P. Nayak, learned standing counsel, finance department, Assam, appearing for the response number 2. Mr. Who is for the pension and public grievance? Miss M. Bhattacharjee, learned government advocate, Assam, additional senior government advocate, Assam, appearing for response numbers. Achha, Mr. Nayak for 2 and 7.
2 and 7.
And Ms. Bhattacharjee for response number 3. And Mr. C. Borua, learned standing counsel,
AG.
Office of Accountant General, bracket AEB, bracket close Assam, for the response number 4. None has appeared for the BTC authorities. Full stop. The case of the petitioner, in a nutshell, is that she was appointed as a master role worker under the in the establishment of executive engineer, public health engineering, Tangla division, Tangla, Udalguri, bracket BTAD, bracket close Assam, on 12/3/1991. And since then, she had rendered continuous service for more than 25 years prior to her retirement on attaining the age of superannuation with effect from 30/11/2016. It is also the case of the petitioner that she was regularized as a Khalasi with effect from 22/7/2005. Although the petitioner claims that she was entitled to receive pension, yet contending that she had not fulfilled the minimum requirement of 20 years of regular service so as to entitle her to receive pension, her request for payment of pension has not been accepted by the authorities. Mr. Borbuya submits that since the petitioner has completed more than 25 years, 8 months, 18 days continuous service in the department, hence, the said period of has, as per the decision of this court in the case of Sanjita Roy versus State of Assam, reported in Sanjita Roy and others versus State of Assam and others, reported in 2019, bracket 2, bracket close GLT 805. The deficit of the regular service ought to be covered by borrowing the period of continuous service she had rendered prior to regularization so as to reckon the 20 years of service as per the pension rules. First up, Mr. Borbuya therefore submits that this is a fit case where a writ of mandamus is required to be issued, directing the authorities to grant pension to the petitioner. First up, Mr. Nayak, learned SC Finance Department, Assam, submits that in view of the decision rendered in the case of Sanjita Roy bracket Supra, the petitioner's case deserves consideration.
One line. Initially, department issued a notification for deducting the initial 6 days. Sanjita Roy held, no, the entire period has to be taken note of. Subsequently, Lords of Supreme Court in 3156/2023 held, only the deficit period is to be taken account. It means Lordship petitioner will not get the full pensions, he will get only the proportionate pension. That is my submission.
Deserves consideration. However, Mr. Nayak, however, mentions that it may be a case where the petitioner may only be entitled to proportionate pension in view of the deficit period of service. First up, Mr. C. Barua, learned counsel, has also submitted that in view of the decision of this court in the case of Sanjita Roy bracket Supra, the case of the petitioner would deserve suitable consideration. Similarly, the stand of other departmental counsels present in this case. First up, in the case of Sanjita Roy, a similar issue, Sanjita Roy Supra, a similar issue arose for consideration before this court, where a number of master roll workers, despite having been regularized in service, were denied pension due to shortfall of regular service. First up, after taking note of the facts of the case and in view of the fact that those petitioners had rendered continuous service in the department prior to their regularization, the learned single judge had made the following observations in para 31, page 51 in video, which is reproduced here in below. Since there is no dispute about the fact that the petitioner's claim comes within the purview of the decision in the case of Sanjita Roy, this writ petition is hereby disposed of with a direction that the respondent shall examine her claim in the light of the order, in the light of the judgment and order, in the light of the decision rendered in the case of Sanjita Roy, and thereafter pass appropriate order sanctioning her pension as may be found to be due and payable to her under the rules. Full stop. The aforesaid exercise be carried out and completed as expeditiously as possible, but not later than 3 months from the date of receipt of a certified copy of this order. All the respondents are directed to render cooperation in the matter of compliance of the order of this court. Writ petition stands before the
My lord, it may be
My lord.
he, my lord, instead of she one. He,
My lord, only.
male, my lord.
Acha, it is the mail. We, not.
So we have paid some amount, issued and that should be adjusted.
Within the period of 3 months,
If-
after adjusting any
yes.
retirement dues.
If
already paid,
any amount is
paid
paid,
to him.
that will help us.
if already paid to him.
Oblige.
He or her, not she.
Item 28.
May I please, your lordship? Your lordship, claim of pensionary benefit as unmarried daughter. Lordship, it is the
I am appearing on behalf of Learned Series Miss R. David Lordships. Instruction is yet to receive. We have communicated with the Principal Controller of Defense Accounts also, Lordship.
2024 matter will give him one last chance. Mr. SB National Learned Council with the petitioner is present.
R. David,
Uh-huh.
Miss R. David, on behalf of R. David.
The learned CGC, Ms. R. Davis submits that instructions are still awaited. Stop. Therefore, prayer has been made to post this matter again after 4 weeks. Prayer allowed. Let this petition be listed again after the puja vacation so as to enable the learned CGC to obtain instruction.
Lordship, oblige, Lordship.
Item 29.
Your lordship, I have received the instruction, I want to file my affidavit. One more thing, lordship, we have not made the first wife as a party.
No, already is, she has.
But she is there, lordship, first wife is.
For that, if the
Lordship.
Already remarried to another.
council is present for the petitioner, Mr. S.S. Roy, learned CGC submits that he has, Mr. H. Das, submits that he has received instructions and therefore be granted 3 weeks time to file affidavit. Should I allow? Let the matter be listed after the affidavit is filed.
Item 30.
That suspension, deemed suspension matter, my lord, where Lord, he was reinstated. Thereafter, he has not been allowed to join discharge duties and not being paid his salary, only subsistence allowance being paid.
Well, departmental proceeding has already been initiated, my lord.
But he has been reinstated.
Well, he has not reinstated.
So this is the order of revocation, my lord.
Well, that is not he's not a competent executive engineer, is not a competent authority, my lord. To issue the suspension order and to issue the reinstate. Suspension order is issued by the Secretary Personnel B, my lord.
Where is the suspension order?
My lord, the suspension order, my lord, lordship will find, my lord, at page 16, my lord. The writ petition, my lord. It was issued to the executive engineer, my lord.
But my instruction is a suspension order is that, my lord, I have submitted a document 19 March 2024 issued by the Deputy Secretary PWD Department. Well,
Now, my lord, we have not received any communication, my lord, of these, my lord, instructions.
Suspension order is page
16, my lord.
So he was arrested, deemed suspended.
Yes, ma'am. They got
Yeah.
bail, my lord.
Then what happened after within 90 days? That is
Well-
21st of May 2024. Was there a review?
No, my lord. To our instruction, we don't have any instruction to the review, my lord. In fact, on 28, page 28, my lord, the executive engineer says that he doesn't have the jurisdiction and revokes the suspension order.
So suspension was made by the executive engineer.
Yes.
my lord, no. Deputy Secretary Personnel B, my lord. That
No,
he had,
page
my
16
lord.
shows that is executive engineer.
But he is not the authority, my lord. So the, my lord, suspension order subsequently issued by the Deputy Secretary Personnel B, my lord. We have submitted, my lord, the documents, my lord.
Have you got this?
No, my lord, that's what I'm saying. We have not
Give him a copy.
received any
My
communication.
lord, we will file the affidavit, my lord. Next, my lord, next document, my lord, annexure 3 is the, my lord. The Secretary Personnel B has already been appointed, my lord, enquiry officer to make the enquiry also.
Give him a copy at
My
least.
lord, my lord.
Let him, if you want
My
to
lord.
challenge, let him
Yes,
challenge.
my
Heard
lord.
Mr. Ahmed, the learned counsel for the petition, also heard Mr. J. Chutia, learned standing counsel, AAC appearing for the official respondents who submit that since the earlier order of suspension was issued by an authority not competent under the law to do so, namely the executive engineer, PWD Dokmoka Roads Division. Hence, the Deputy Secretary, PWD KAC DFO has now issued a fresh order of suspension dated 19
Mars, my lord.
now had issued a fresh order of suspension dated 19/3/2024, placing the petitioner under suspension after the revocation of the earlier order of suspension by order dated 18/3/2024. Mr. Chutia further submits that a departmental proceeding has already been initiated against the lead petitioner and an inquiry officer.
Suspension, my submission is suspension order not revoked, my lord.
No.
That is the letter only, my lord. The petitioner referred to a letter, my lord, only. Letter written by the
After
executive engineer to
after
the,
the
my lord.
communication dated 18/3/2024 issued by the executive engineer PWRD Dokmoka intimating the authorities. It has been immediately revoked. That is what he
My
writes.
lord, he writes, my lord.
Then we'll go by what is there.
My lord.
After the revocation of sanctions by appointing an inquiry officer. Mr. Datta, however, submits that his clients do not have any information on the above developments. In view of the above, and on the request of Mr. Datta, this matter stands adjourned for 2 weeks so as to enable him to obtain instruction. In the meantime, the KSC authorities shall bring their
Bring it on record by way of affidavit.
an affidavit.
My lord. Oblige, your lordship.
Item 31.
Please, your lordship. This matter is relating to pension, lordship. I have also challenged the order dated 26/4/24, passed in departmental proceeding, lordship, against me.
Yes, who's appearing in this case?
I am appearing, Lordship.
What do you have to say?
Lordship, as of now, we have not received the para-wise comments, Lordship. But here only in para 17, he has agitated. Other than he has not stated anything regarding the illegality of the order that has been passed, Lordship.
Where is the order?
Order is in the last annexure, Lordship.
There's no
Page
third-
38, Lordship.
30. Seventeen, 18, 19, Lordship, all are 16, 17, 18, 19.
There is an order of penalty. It's not a case of non-payment of pension.
Yes.
Why are you
Okay.
making this submission? You heard Mr. So-and-so and council.
Lordship, I have not received till that provisional pension also, Lordship.
Also heard Ms. Embadagul, additional senior government advocate Assam appearing for the respondent who submits that instructions are still awaited and therefore 4 weeks further time be granted to obtain instruction. Full stop. Prayer allowed. The learned government advocate Assam to also obtain instruction and appraise this court as to why provisional
Lordship.
pension would also not be granted to the petitioner, notwithstanding the order dated notwithstanding the order dated 26/4/2024, bracket annexure 11. Let her obtain instruction.
Yes, Lordship.
Lordship, can you see last page, Lordship?
Let her obtain instruction. There are problems in your matter. There's a departmental proceeding and governor has forfeited the part of your pension. Instructions will be necessary.
Supplementary list for admission, item 56.
May it please the watch.
Yes.
Well, the petition is otherwise ready for disposal. And matter relates to the claim of regular status by the petitioners. The core question would be whether the petitioners who have been rendering 14 years of service as the accredited engineer in the rank of junior engineer, having been selected and appointed through a regular process of selection, advertising, are entitled to be regularized and brought into the cadre of junior engineers with regular pay. That is the core question.
This matter will take some time.
Little time will be required. From 20, it is pending. Of course, we are there working as an accredited engineer with a fixed pay. We are there. For last 14 years, we are working.
Who is for the other side?
The department is there, Mala.
They are there, but they are not there.
No.
I'm appearing on behalf of Mr. P. Nayak. He's on his way, Lordship. It's a matter will be taken up after some time.
She may conveniently fix the matter of the hearing date so that we can trust of. In this week itself, if
So
possible.
pleadings are complete.
Sorry, yes.
Pleadings are complete in this.
Yes, Lord.
Then why don't we fix it for final hearing immediately after vacation? On a non-miscellaneous day? We can fix it before vacation, but it will go after vacation, you know it.
It may not materialize. So it may not be taken up before vacation. Lordship, may fix it immediately after so that.
But Mr. K. K. Mohan, senior counsel appearing for the petitioner, also heard Mr. P. Nayak, Land Standing Counsel, Finance Department, as well as who else?
Respondent of 5 minutes. Be served.
Appearing for the
Last week to
respond number 2. Who is for the PNRD department?
Not PNRD, in this case, I am appearing.
Standing Counsel, Finance and PNRD Department, Assam, appearing for the respond numbers 1 to 4, and Mr.
P. Sharma.
B. Sharma, and a counsel appearing for the respond number 5. it is submitted at the bar that this matter is ready as regards pleadings, since the issues involved in this case would require in-depth consideration. Hence, a request has been made at the bar to fix this matter for final hearing on a non-miscellaneous day for expeditious disposal of the writ petition. Having heard the submission of learned counsel for both the sides, as well as after considering the issues involved in this writ petition, this court is of the considered view that the matter would call for deeper consideration. As such, issue rule returnable on 29th of October. 29th of October.
29th of October, my lord, let it be on 5th of November.
5th of November.
Yes.
Since the respondents are already represented, no further notice is required to be sent in this case. Registry to list this case on 5th of November 2024 as a fixed item in the top of the column of hearing matters, with an understanding that no further adjournment will be sought in this case on the next date.
Obliged.
By either side.
Daily list for orders. Item 33.
My lord, the petitioner intends to ignore the case. They have informed me that some of the demands have been negotiated with the authority.
All right, Mr. C. Dekal and counsel for the writ petitioner submits that during the pendency of this writ petition, some of the grievances of the petitioner have been addressed by the authorities, and therefore he has instructions from his client to withdraw the writ petition. Mr. S. P. Das, learned counsel for the respondent number
3 and 4, my lord.
3 and 4, and Mr.
And for the private
Siddharth.
respondent, 46, 52, 55, and 60.
Appearing for some of the private respondents, as well as Mr. J. K. Goswami, learned government, additional senior government advocate Assam, are present and do not have any objection if the prayer is allowed. In view of the above, on the prayer of the writ petitioner, this writ petition stands disposed of on which that. Is there an interim order?
For in report was vacated earlier.
Item 35.
None appears for the petitioner on call. This matter stands adjourned for 3 weeks.
Item 36. 36.
Millard, regarding 35, Millard, I beg to withdraw the matter. Since matter has almost become infructuous now, only of academic interest. But which liberty, Millard? If
Liberty, how can you withdraw at this stage with liberty?
Millard, then
Peter
Millard,
Legal Learned Counsel for the petitioner submits that due to passage of time, the issue raised in the writ petition has lost its force.
Millard.
And therefore, he has instructions to withdraw this writ petition with liberty to approach this court as and when fresh cause of action arises
Millard.
in the matter. Full stop. The prayer is not opposed by the respondent's counsel. Whose?
In 35, I am on behalf of 1, 2, and 3.
By Mr. J. K. Goswami, learned additions, senior government advocate Assam, appearing for the respondent numbers 1, 2, and 3. In view of the above, this writ petition stands disposed of with liberty as prayed for.
Millard.
Fresh cause of action.
Millard, most obliged.
Is there a IA with it?
Millard.
Obliged. Okay. Now 36, yes.
36.
This is regarding non-compliance order is at 28/6/2019, my lord.
Mr.
Regarding
Lordship.
compulsion appointment, my lord.
Lordship, my senior is is on legs. Can we take the matter after some time?
No, what is the instruction then?
Okay. I have filed one additional affidavit regarding vacant position of the TLC, your lordship. That I have filed on 6/12/2023, your lordship.
So have you received a copy of that?
My lord,
Any response filed by you?
no, my lord, not required, my lord. Actually, they have not taken the vacancy position of all the departments, my lord.
All the departments I have mentioned in
Well,
page number 63, your lordship.
My lord, kindly go for the additional affidavit, my lord.
Mr. Counsel, you better file your response to this, otherwise we'll close the contempt case. Your oral stand will not do. You want to file it or not, you decide. You want to file it?
Sometimes my
All right, Mr. Your name, please.
JP Chauhan.
JP Chauhan, counsel for the petitioner, 3 weeks further time to obtain instruction and if necessary, file rejoinder in response to the additional affidavit filed on behalf of
Respondents are fine.
Respondent number 5, your lordship.
respondent number 5. Prayer allowed. Ms. K. Phukan, learned counsel is present for the respondent number 5. You are appearing? Mr. D. Nath, learned counsel is present for respondent number 1.
Obliged, your lordship.
Is also present for respondent.
Item 37 and 38.
May please your lordship. My lord, this rejoinder affidavits are ready, lordships, but these petitioners are communicated, lordships. Proceed matter will be taken up after vacation, lordship.
Mr. R. Sharma, learned counsel for petitioner submit that rejoinder affidavit on behalf of this client is ready, but 3 weeks time be granted so as to bring the same on record. Mr. B. Chaudhary, learned counsel for the respondent, does not have any objection to the parallel. In view of the above, let this matter be listed after the ensuing puja vacation. Thank you.
Item 39.
Matters.
Dispose করে দিলাম ভাইয়া। Copy লিখে তো ওরা। এটাও বলে এক কাউন্টারে কইছি। Lordship, it's compliant, lordship, as per the direction of the.
Lord, I have not been.
Show it to him, show it to him.
Lordship, I have the copy.
And
This
Mr.
copy
D.
was-
Naval, learned counsel for the petitioner also heard Mr. J. Hendik, learned counsel for the respondents who has produced a copy of the order dated 1/8/2022 issued by the Deputy Commissioner Hemaji to submit that order of this court has already been complied with. It appears that the representation submitted by the petitioner has already been disposed of with a speaking order. In view of the above, this contempt case stands closed with liberty to the petitioner to avail appropriate legal remedies as may be permissible under the law, if so advised.
Lordship.
Item 40.
Lordship, पहले से last order मतलब 17/11 में लड़।
What has happened to the appeal?
Nothing में लड़।
No stay order.
No state of order.
Where is the order?
Admitted.
Last order, you produced the last order. On the request of Mr. Mubarak, learned counsel for the petitioner. This matter stands adjourned for 10 days, shows to enable him to obtain a copy of the last order passed by the court in retaping number 279 of 2023,
Lordship.
Item 42.
passed by the division bench.
I'm sorry, Lordship, item 40, I am there, Lord. Item 40.
Yes, Bhakti, what has happened?
40, Lordship, retail is pending, Lordship.
The last order, Mr. Anupadhyay, learned counsel is present for the response.
Obliged, Lordship.
Yes, please.
Lordship, order was communicated to the authority. Lordship, kindly have a look at page 8 on 26/6/2020. Thereafter, page 8, Lordship, kindly.
Mr. C.K.S. Barua, what is this Director of Social Welfare not responding to the contempt proceeding of this court?
Long back eligible post of director. Jurifukan name is shown.
Who is the Director of Social Welfare now?
Presently, Mr. Rahul Das. Mr.
Then-
Rahul Kumar Das. Jurifukan left 2-3 years back.
All right.
This is the.
Mr. L.R. Majumdar, learned counsel, for the
That time
petitioner
was
prays for and is granted 3 weeks time to find appropriate application for improvement of present incumbent in the office of Director of Social Welfare Assam. Let this matter be listed again after the IAS.
Online.
Item 43.
My lord, we have filed affidavit in reply to the affidavit in opposition. My lord, kindly let the matter be fixed for final hearing.
Lordship, yeah.
Mr. Your name, please.
D. Rathi.
D. Rathi, Learned Counsel for the petitioner, Ms. M. Bhattacharjee, Learned Additional Senior Government Advocate, Assam, appearing for the respondent, submits that pleadings have been exchanged in this case and the matter can be taken up for final disposal at the stage of admission hearing. In view of the above, and as agreed to by Learned Counsel for both the sides, let this writ petition be listed after the reopening of the Puja vacation on a non-miscellaneous day for admission hearing as a fixed time.
My lord, any date may be fixed.
It will come up.
Much of.
Obliged.
May I please, Your Lordship. Lordship, we have filed an IA for correction of name and address of respondent number 9. IA number 2613/2024.
Correction where?
Correction of respondent number 9. It has been mistakenly written as the water user committee represented by its secretary in the cost title, Lordship.
Cost title of what? Writ petition.
Writ petition.
Then you have to file an application for amendment of the writ petition. Correction cannot be done like this. Do you have any objection?
Respondent number 9 now.
You have made a mistake. You correct it by seeking. This is not a correction of a court error. You want amendment of your cost title.
Lordship,
Actually, he wants to amend the address and the name.
name and address
Perhaps
of
the
the
secretary has changed, that is why.
Yes.
Then it's a application for amendment of the writ
Yes.
petition. Not correction.
Lordship, while making the copies of writ petition to serve the notice upon the respondent number 9, it has come to.
We are not asking you when you came to know. You have to file an application for amendment of the writ petition, not correction. On the request of applicant's counsel, this matter stands adjourned for 10 days so as to enable him to examine and address the court on the maintainability of the IA.
In 46, item 46, Lord, can you give me 10 days time, Lord? I'll file the affidavit for R1.
Learned counsel for the petitioner, Mr. H.R. Ahmed, is present. On the request of Mr. D. Nath, learned counsel appearing for the respondent number 1, 10 days further time is granted for filing affidavit. Next matter according. Yes.
My lord, yes, service is completed, my lord. In the cause list, my lord, name has been shown, my lord.
Mr. D. Saikia, B. Chaudhary, no. Where are these? D. Saikia means who? Mr. Devajit Saikia. Advocate General appearing in contempt case.
Since they are appearing, my lord, let the matter be listed for admission, my lord.
Admission of contempt case. Nobody seems to be aware of anything. Fantastic, everything. Mr. D. Baba is present for the petitioner. However, the respondent's counsel is absent despite the fact that the name of the counsel is shown in the cause list. In order to give one final opportunity to the respondents to appear and argue the matter, this case is directed to be listed again on 23rd.
Of this
As a
month?
fixed date. Yes.
Oblige, your lordship.
48.
How many cases are there? What is this hearing matter? Who is appearing?
My lord, here
It will take only about 10 minutes, my lord. That short matter, can it be fixed on 30th of this month, my lord? Because the petitioner is deprived his salary also, my lord. The bank is handed over to the contractor running away. So what do you want it to be fixed on 30th? Yes.
So we need to file the affidavit in opposition. In the meantime, we'll file it.
Yes. Mr. R.P. Sharma, learned senior counsel is present for the petitioner. Mr.
H. Buragoy,
H. Buragoy, learned counsel appearing for the
1 to 6, Your Lordship. Respondent bank.
1 to 6, please, for 10 days time to file counter affidavit. Expressing urgency in the matter, Mr. Sharma has prayed for posting this case again on 30th of September 2000. Give me this as a fixed item. Prayer allowed. Let this matter be listed for admission on 39/2024. What is this hearing matter about?
Lordship, on the last occasion, Lordship, on Thursday, Lordship has heard the matter and Lordship has instructed.
Ask me to obtain the record.
Record,
Lordship, I have received the record during the court hours today. May I be allowed a daytime, Lordship, to go through this, Lordship?
Lordship,
All right, we call up the other matters.
yes,
We'll
Lordship,
ask-
yes, Lordship.
May please, Your Lordship. Also matter related to non-payment of retirement benefits. We have filed the delay petition followed by setting aside petition and that substitution petition.
Matter relates to what? What is this IA about?
My lord, this IA, they have filed, the petitioner has expired, my lord, so they are filing this IA for substituting the names of the legal heirs of the petitioner. So we have no objection, my lord. Let them.
And there is a delay petition also.
Yes, sir.
What is the case number?
The IA 1544/2024. That is for the delay.
1544. 1545 is this. Okay, you take down. This IA has been filed. 1544 of 2000. This IA has been filed with a prayer to condone the delay of 218 days in filing the application for setting aside abatement of the contempt case and also for substitution of the legal heirs of deceased petitioner. I have perused the grounds stated in the IA explaining the delay. Mr. Your name, please?
A.D.
Huh?
A.D.
A.D.
A.D. Yes.
Learned counsel appearing for the opposite party submits that he has no objection if the prayer is allowed. In view of the stand taken by the learned counsel for the opposite party and considering the explanation furnished by the applicant, this court is of the opinion that the prayer made in this IA deserves to be allowed. As such, the delay of 218 days in filing the connected application is hereby condoned. The IA stands allowed. Then IA number 1543. This IA has been filed with a prayer to set aside the abatement of the contempt case due to the failure on the part of the petitioner to file application for substitution within the prescribed period of limitation. I have perused this one, so does not have the same allowed. Then IA number, which is the application for substitution 1545 of 2025. This IA has been filed with a prayer to substitute the legal heirs of the deceased petitioner as described in paragraph 3 of the petition. Mr. Day, learned counsel for the opposite party, submits that he has no objection if the prayer is allowed. It appears that the original petitioner, namely Sri Rajan Boro, has expired during the pendency of the contempt case, leaving behind his legal heirs, namely Narani Boro, bracket wife, Junmani Boro, daughter, and Sopan Boro, son. The names and particulars of whom are given in para 3 of the IA. First of, since the in view of the stand taken by the opposite party, counsel for the opposite party, and considering the statements made in the IE, the application for substitution of legal heirs of deceased petitioner stands allowed. The three legal heirs of deceased Rajan Boro shall be implemented as respondent as petitioner numbers 1 Roman 1 to 1 Roman 3 in the contempt case. The applicant's counsel to file amended cost title in the contempt case within 10 days from today. Registry to thereafter release the contempt case for necessary order. IS stands disposed of. Yes. Item. Yes.
May I please, Lordship? Lordship, as per the latest office of Lordship, service has been completed, Lordship. So let the matter be fixed for admissions, Lordship.
It is submitted at the bar that this matter is ready as regards service and therefore be listed for admission. In view of the above, registry to list this case for admission by reflecting the name of learned counsel for all the respondents appearing in this case.
Lordship,
Up to X.
Lordship, as per the order dated 3/6/2024, Lordship, there is an interim, Lordship.
Interim order passed earlier to continue.
High level.
Lordship may kindly peruse order dated 9/8/2024. Lordship, therein the interim prayer was kept open. Today was the date fixed for consideration to interim prayer. Your Lordship, I want to place certain developments had taken place after filing of the writ petition. After basically the issue here involved is recasting of the seniority list. On the basis that,
So I'll not take note of this. You have to place it on record.
Your Lordship, I agree, but the facts of that what I've annexed in the writ petition itself, my learned friend will also agree to the fact that the seniority was fixed on the basis of one particular date. And on that basis itself,
You don't want to place this on record or this is not necessary? You
not
can,
necessary at this point. I may just take your Lordship to just one
then
particular.
we'll sit again.
Your Lordship.
But I will not give you a chance to place
Yes,
it on
yes,
record.
yes,
So I will not even look into it.
yes. Organization, and therein the only sole player in this particular writ petition is for recasting of the master seniority list, MSL. Now, what had actually the defect which has crept into this MSL is that the people who were actually got lesser marks than the petitioners and who belong to SC/ST category, they were placed higher than the petitioners who belong to the unreserved category. And the only basis for differentiating this is that the trade test, which is a component of the whole selection process, which comprises of written examination, trade test, viva voce, the marks obtained in that has the petitioner had got more marks than the private respondents. But what had happened, private respondents were placed higher than the petitioners. I had actually given tabular representation at page number 22 of the writ petition as to how I'm aggrieved. If your Lordship may kindly go to page number 22, I'll be able to show your Lordship as to how I'm aggrieved and why this heartburn has actually caused to the petitioners.
Lordship, my instruction is that we have constituted a board of officers to examine the matter, so it has been kept in hand.
My only prayer at this stage, your Lordship, because DPC, what I wanted to place was that DPC is almost going to be convened on the basis of this fallacious MSL. What I'm praying as an interim prayer, DPC may not consider the case of the respondents,
Without finalizing the.
without fight, because this they have
This under consideration.
they themselves are actually admitted to the fact that there is something wrong in this MSL. And that's what I wanted to place before your Lordship. Nothing otherwise, I don't want to file an additional affidavit to that effect. Just the latest status.
G, Lordship, the point G.
And I wanted to place the BO order. They are supposed to finalize it by 30th of September.
All right, take down. Heard Mr. D. Bora, and counsel for the writ petitioner, also heard Mr. B. Chakravarti. And CGC appearing for the respondents will stop.
Only the official response, there is some private
Official respondents. The petitioners hearing are serving as junior engineer, bracket civil, bracket close in the border roads organization. Will stop. They are aggrieved by the master seniority list prepared by the authorities on the basis of trade test bracket TT held recently. Full stop. According to the petitioners, the private respondents who had scored lower marks than them have been erroneously placed above them, thus causing serious prejudice to their interest. Full stop. Mr. Bora submits that based on the erroneous master seniority list, the departmental authorities are contemplating to grant promotion to various junior engineers if, full stop, if the said process is permitted to go ahead, then in that event, it would cause serious prejudice to the interest of the petitioners. Full stop. Hence, a prayer has been made for issuance of an interim order in this case. Full stop. Mr. Chakraborty, known as CGC, on the other hand, has obtained instruction in the form of pair-wise comments and placed the same before this court. Full stop. As per the response pertaining to para 11 of the writ petition, it appears that a board of officers is being constituted shortly so as to examine the discrimination in the preparation of master seniority lists of junior engineers, comma, if any. Full stop. It is also reflected that if necessary, a fresh revised master seniority list will also be prepared by the authorities. First up, Mr. Chakraborty submits that until and unless the aforesaid process is completed, no exercise for promoting the engineer.
That admission may put me in difficulty, Lordship.
That's it. Then you write. It is therefore apparent that a process has been undertaken by the authorities for reviewing revisiting the MSL, a master seniority is to cover MSL available. First of all, if that be so, the respondents cannot be permitted to go ahead with the promotional process before completing the process of revisiting of MSL. First of all, it is therefore provided as an interim relief that until and unless the exercise as contemplated by the departmental authorities for revisiting the MSL is brought to its logical end, no final order of promotion to the officers in the rank of JE civil shall be issued.
Lordship may fix after vacation.
Let this matter be listed again after 6 weeks. In the meantime, the learned CBC to obtain necessary instruction, updated instruction.
Highly obliged.
Please, Your Lordship. In this matter, Your Lordship, on last time notice was issued, Your Lordship. I have taken steps, Your Lordship, and respondent has also appeared, Your Lordship.
He is a private respondent here.
Yes, Your Lordship.
So what is, today it's to be disposed of?
Matter will be posted on admission column.
Admission.
Achha. All right, Mr. J. Laskar, Learned Counsel has entered appearance in the response number 6. The official respondents are represented by Mr. S. Datta, Learned Standing Counsel, PNRD Assam, as well as Mr. C.K. Bobo, Learned Government Advocate Assam. In view of the above, this writ petition is ready as regards service. On the request of Mr. K. Mira, Learned Counsel for the petitioner, this matter be listed for admission after 2 months.
There's an interim order, Your Lordship.
Interim order passed earlier to continue.
Oblige, Your Lordship.
My lord, matter relates to transfer, my lord. On the last occasion, notice has been issued to the private respondent, my lord. And they have already appeared, my lord. So matter will come up for admission, my lord, for disposal, my lord, before puja vacation.
Heard Mr. K. Sinha, learned counsel for the petitioner. Also heard Mr. S. Datta, learned standing counsel, PNRD Department, Assam, appearing for the respond numbers
1 to 3.
1, 2, and 3. Mr. Yu Khan, learned counsel, has appeared on behalf of the respond number 4. As such, this matter is ready as regards service. Office 2, therefore, list this case for admission.
Obliged.
Supplementary list for hearing at
Lordship, this matter, Lordship has heard on Thursday, Lordship, this matter pertains to Lordship a parallel proceeding, Lordship, or criminal proceeding as well as the departmental proceeding. In the criminal proceeding, Lordship, I have been acquitted, Lordship. And the same set of charges and Lordship, the same witnesses, they have initiated the departmental proceeding in the meantime, in the pendency of the criminal proceeding. And on the last order, Lordship has called for the records from the
I
respondent.
have received the record, Lordship, but I could not have the time to go through. I received it today in the 4 hours, Lordship.
So when? Thursday?
Yes, Lordship.
Mr.
Subject-
DJ Das, learned counsel is present for the writ petitioner. Ms. M. Bhattacharya, learned additional senior government advocate Assam, submits that she has just received the records and needs 2 days time to go through the same. In view of the above and on the request of petitioner's counsel, this matter is directed to be listed again on 19th.
Lordship, there is an interim Lordship that may be continued. Inadvertently, Lordship, on last date, Lordship, the interim was not continued, but there is an interim.
9/2024 as a fixed time.